Yes.
I'm praying for non-deletion of the matter.
On?
I appear for 801, my lord. I appear for answering respondent.
It's coming on 9.
Yes, sir.
All right.
Deeply.
Next.
My lord, main matter is coming on 14th May. So list all these matters with the main matter, that is SLP civil number 30217 of 2024.
All right. They're all coming on 14th May. इसको भी लगा दिए साहब. Huh? Date is not showing. No, in the connected
No,
matter.
in the main matter it's showing. In the
Okay.
advance list it is also mentioned.
What is the number of the main matter?
My lord, 30217 of 2024.
That is the main matter.
Yes, my lord.
STS ladies.
Yes, yes, ma'am.
चेक कर लीजिए अगर है तो लगा दीजिए. नहीं है तो मतलब.
Grateful. I have also annexed the order with.
All right.
Grateful.
Yes.
Please, my lord. My lord, the matter is, there is no date is showing, my lord.
Maintenance of wife and 3 children.
Yes,
All
my
right.
lord.
Date लगाइए भाई, जल्दी date लगाइए. Today is 7th. 20th May.
Keep level.
So this matter is showing for 21st of May, not to be deleted.
Not to be deleted.
Because pleadings may be completed meanwhile, if that my lord would be kind enough to add.
Pleadings are not complete.
Because the state has not filed the counter.
It is still defective.
No, my lord, we have already cured the defects in all of them, my lord. The registry, there is some problem at the section level. They are doing it from their side, my lord. They were assured by tomorrow they will do it. From our side, everything is completed.
Subject to curing out defects, huh?
Very well, my lord.
Right. Next.
805 is also not to be deleted for the same day, my lord.
All right.
And same for 6 also, my lord.
All right.
Its pleadings may be completed.
All three by Mr. Mandeep Kalra.
Indeed.
Lords, may I seek one
The
small
pleadings-
indulgence?
The pleadings may be added, my lord. Pleadings may be passed.
Pleadings may be completed in the meantime.
So grateful, my lords. Deeply grateful.
We please, your lordship.
Yes.
You were unlisted mentioning this. One is item 34. What is the games, betting, gambling versus game of skill matter started on Monday? The ASG is finished yesterday.
So what do you want?
I'm on my legs the whole in a regular part today. I want an adjournment in 34. There's no objection.
Today's list.
Today's list,
Yes.
item 34. There is another matter, for the same reason, which is I don't have the consent. It will be contested. Item 2. This has come for lordship for the second time. It has not been reached in your lordship's court ever. Then somebody.
My lord's 11th time.
1 second, allow me to finish, please. Your lordship said top of the board today. Now I'm in a partner, your lordship may give any date for it. I can't do it, because I'm on my legs in party.
What is this matter about?
Dearness allowance, my lord.
Sir, but I can explain. West Bengal dearness allowance matter of large consequences for the state of West Bengal. I am for the state of West Bengal.
The state of Bengal is the petitioner here.
Yes. So it's a matter of large monetary consequence. It will require some time also. But whatever date your lordship gives, will adjust and come. But it won't be possible in the very immediate future. That's all I'm saying.
My lords, 11 times, if I may, my lords. My lords, I am for the employees. My lords, 11 times it has been listed. In January of 2023, it was ready for final hearing. On the last occasion, in March, on the 25th of March, therefore, my Lord Justice KAROL had said that it must be placed high up on the board, and my learned friend was there. And then we mentioned it on the 1st to say not to be deleted and kindly place it high up on the board, and so it's top of the board today, my lords. So, my lords, of course, we would love to accommodate Dr. Singhvi, no question. The difficulty is that
The date will fix it.
tomorrow, my lords, either 2 o'clock or tomorrow.
Tomorrow is it admitted matter?
My lords, it's not, no, but it is for final hearing. It's been for final hearing since 2023, my lords.
Can come on Monday.
Actually,
Tuesday.
should be a leave.
My lords, it's Tuesday. No, my lords, my lords. We have 1 in 6 fora, my lords.
Stay operating.
6 fora, my lords, and there is no stay operating in their favor.
In July, it should be in July. No. Parties have. The matter will take some time. Parties have agreed.
That's why
My lords, they have said do not continue with the contempt proceeding. And my lords, they are in very serious difficulty.
Never reached. We did not seek adjournment, never reached. Whereas if your lordships
My lords, might Thursday be possible of next week?
Thursday, I'm not, I have to
Not
open
Thursday.
Wednesday, not Thursday.
My lords, Wednesday. My lords, in that case, Wednesday. My lords, Tuesday, I'm in some difficulty. Would Wednesday be possible?
14th is Wednesday.
Would your lordship
Wednesday, I'm so grateful. my lords.
want us to start at Wednesday at 2 o'clock? Can I start at 2 o'clock on Wednesday?
Today?
Wednesday. You're giving Wednesday. Can it be 2 o'clock? Because I'll start at 2 o'clock.
2 o'clock.
Yes, my lords. 2 o'clock.
There is serious opposition. The request made by Dr. Singhi for an accommodation
Because 17 times.
come up by the learned counsels appearing for the respondents. Full stop. On the agreed date, list this matter on 14th May 2025 to be taken up at 2 p.m.
I'm very deeply obliged. Well, the other matter, your lordship has got no objection. Item 34.
34, of course.
July, some date, your lordship. Court
21 in July.
No, whatever, July, August, whatever.
This one was 34 in which there was
This one was 2, my lords.
Item number 34 is any date your lordship will give, whatever your lordship wants, from August or whatever.
Item 34, what date do you want?
I mean, whatever, August, there's no urgency either way.
List August 2025.
Very, like.
We're grateful, my lords.
Please do.
Plus, this is a matter which is coming on Friday, Millets, after notice was issued.
What do you want?
Plus, I need a day's accommodation. I'm in some personal.
Lieutenant there, please, no mention otherwise.
Yes,
Persons
because my-
on indulgence.
so that your lordship doesn't have to go through the paper.
We'll accommodate, no difference.
Persons
Wait,
on-
please, your lordships.
Just 1 minute.
One
Lord,
small
I am
indulgence.
appearing-
I have prepared a chart.
1 minute. We
Yes.
see the chart.
Yes.
We want the orders.
Orders as well.
For 1 minute. For 1 week, the orders could not be uploaded. You know, we don't take more than 24 or maximum 48 hours for orders to be uploaded.
My lords.
Because of you, we are facing the problem.
My lords.
So you were very clear. You were in each case, you were to give us the copy of the order because we did try to take it out ourselves. It is not on the website. The owners, we held you responsible for it.
My lords. Now may I just submit a chart, my lords?
We don't need
I
the
have,
chart.
no, I have the copy.
We
My lords,
don't
may allow
need
me to
the
complete.
Please.
My lords, may allow me to complete. My lords, out of the 88 matters, I am there only in 4 matters. Nonetheless, what I have done, my lords, I have got in touch with my other colleagues who are representing the respective parties and we have got all the orders. So barring 3, all orders are available. There's a set that I have prepared which runs into roughly 500 and odd pages. I also had a word with your lordship's court master last evening and I'll be submitting everything with them. So this is just only to appraise your lordships that everything is ready and with all necessary details, everything will be submitted now.
Don't give hard copy, give it in a digital form.
I'll do that as well, no difficulty at all.
Don't say as well, only give it in various
No.
paper.
There's a difficulty, my lords. Certain orders are of 1996, 97, 2002, 2003, 2001, 1992. They are not available in digital form. Even the orders which are available with us.
You give it to us in digital
Yes, yes,
form.
I'll do that today, my lords. No difficulty. I'll do that today again. No difficulty.
Please.
So I'll just submit. So this is just to appraise your lordships. I'll submit this today.
Lordship, where the orders are not available, so Lordship are keeping those matters because
We
in
can't-
some
we have already been disposed of. We have already disposed of.
there are no orders available, Lord.
Not, there are none.
And the respondents are not here.
If the order is not available, we'll say it is an admitted case of the party. Simple as that. We are very clear.
Lordship, Lordship, may I mention item 1? Lordship, it was mentioned.
Today's matter.
Today's matter. Yesterday, Mr. Dharmadhikari had mentioned
Yes,
he is
yes.
in some difficulty.
Huh.
Item 1, I am requesting for some.
Go to the other side.
Council is appearing virtually. He wants to say something. He has raised his hand.
Mr. Councillor, you have any objection in item 1 being adjourned?
Yes, Shamin.
Lord, with regard to the matter which was mentioned a while ago, SLP number 15399, which is listed on Friday before the bench of Justice KAROL and Justice Mishra. My Lord, I am coming all the way from Bombay, my Lord, for that matter. My Lord, I am requesting it may not be adjourned. The SLP number 15399.
The one which
Send it
was,
before Justice Karol had said to mention
On that day.
on that day.
On,
So he's
on that.
so he's
Then
So
it's
I'm
not.
opposed on that date, huh? Yes.
Very,
Yeah, I know.
very.
so Lordship, item 1.
Item 1. You inform the other side.
Yes. Item 1.
When do you want it? July?
Yes.
My lords,
Take reference.
my lords, I'm appearing in 102. I'm led by Dr. Yugmoge Chowdhury. He has difficulty in June. Can it be posted in the first week of August, my lords?
Which one?
Item 1. Item 1. We are in connected matter.
Item 1 is a death reference matter.
Yes.
Yes.
So when do you want it?
August, my lords. August first week.
August?
August.
Very well, August.
August.
First week, my lords.
First or second, whatever. Let it come. First week of August, all right.
It's item 38, my lords. We had mentioned that matter and that's how not to be deleted. I'm requesting let it be taken up today. Anytime which because the bench is still 325s.
No, bench may be only till lunch. There is a possibility. We are not sure.
Then, my lords, may I request because we have filed the IA. This concerns elections of a club, my lords.
Okay.
So there's some.
Elections of a club, what is the urgency?
The urgency is, my lords. The urgency is
notified the election.
The elections have to take place.
Without administrator, they are conducting the election.
No, my lords. I'll show, my lords.
All right.
The commissioner has filed a report before this court.
Try to pick it up.
Friday, my lords. Then may I request that?
Wait, if it doesn't come up, then you make a mention to the CS.
Deeply.
My lord, in the bail matter, the custody notice has been issued, and the matter
Sorry?
in the bail matter, my lord.
Item number?
Unlisted mention. It is not fixed today, but that is unlisted mention, my lord.
Unlisted mention you don't hear.
My lord, only matter is urgent. That's what I'm.
Come to the mentioning board, we will fix it. Considering the urgency.
Okay.
Now you are starting the board.
May I please? My lord, in this matter, yesterday, my lord, the respondent filed the reply affidavit. My lord, if possible, I'm seeing 2 weeks time to file the rejoinder affidavit. He has filed certain documents, my lord.
That's I am appearing as the accused in this case, Milords. But the primary grievance in the SLP is that the money may be deposited in the trial court. He may not be asked to accept the money. The Patna High Court has also modified the order, and I was directed to furnish the money before the trial court, which I have done it. I have bail bonds have also been filed. Charge sheet has been filed, Milords, in this case.
Petitioners, my lord.
You don't accept the money. There's not a mandate on you to accept the money. You already filed a suit.
My lord, we have already. But he's not appearing before the letter.
He is not appealing. That is his headache. Your headache getting served. But what for? What is the ground to cancel the bail fees?
My lord, please.
There is one incident in between. You say there is no injury report. Nothing.
Lord, there are 2 agreements. My lord, dishonestly executed 2 agreements. He received the money. Then my lord,
yes, he received the money and then did not go ahead with the sale.
Yes, my lord.
So that's a cause for filing a suit for specific performance. It's an abuse of process. If you want, we can exercise powers and quash your FIR. Grossest abuse of process. You are just trying to circumvent the civil remedy.
Lordship, from the very beginning, he dishonest intends.
All right, you prosecute him. You feel thankful that we are not quashing your FIR here and there in your now and here in your petition.
Lordship, Honorable High Court says, please only refund the amount. Then, my lord, my purpose of filing
the amount is being deposited. The trial, you are not being forced to accept it. Don't accept it.
But since he did not give us his account, we had his father's account and we transferred 5 lakhs to his father.
My lord, he
is not it may not be the case of the government will have to move.
He decided in bail.
And we've anyways deposited 5 lakh in the trial court.
Bail contest, my lord. If it is, my lord, not a fit case, so if it
plead the condition and confirm the bail.
My lord, may only submit my humble submissions. If it is in the Kendall office,
what do you want?
My lord, we say condition imposed on the High Court, my lord, please, because we are only saying that his bail should be kept. Session court.
Then we, all right, what we'll do is we'll delete the condition of depositing the money. Confirm the bail order.
The appearance willing to have sale.
Mr. Counsel, there can't be two advocates arguing for one man.
Please. In a bail matter, title cannot be decided. He has directed to deposit money. A title, the entry title matter he has decided in a bail matter. Anticipatory. This is not proper. We want to have registry as per agreement.
He anyways will have filed a suit for specific performance. He's pursuing that separately.
He doesn't want you to deposit the money.
Yes.
All right, you say no money.
Yes.
What is your problem? You should be happy with that.
Yes, Milords. We were influenced for that bail bond 5 lakh rupees we've already deposited.
That's not.
Yes, Milords.
That will remain.
Yes.
Likhie. Third counsel, you want deletion of that condition of deposit?
Yes.
What does he want?
I do not want to have received money.
Correct.
Rather,
We will take care of that. Don't worry.
The Honorable High Court.
Will you allow us to pass the order?
In an anticipatory bail matter, he cannot compel to deposit money, cannot decide preemptive title of the appellant.
All right.
It may kindly be made what the order for compliance of whole thing. In a bail matter, title cannot be decided.
The respondent number 2 approached the High Court of Judicature at Patna seeking anticipatory bail in a complaint in an FIR lodged by the respondent, by the petitioner. Full stop. The High Court, by order dated 20th September 2022, impugned in this petition, granted protection subject to deposit of the amount of rupees 80 lakhs, 85 lakhs in 15 monthly installments.
It's 5 lakh at the time of furnishing bill.
In 15 monthly installments. The first amount of 5 lakhs was to be paid, deposited at the time of, for time of processing of the bail bond. Full stop. The grievance of the petitioner is that the High Court, having directed the respondent number 2 to make the deposit, is in effect prejudicing the right of the petitioner in a suit for specific performance pending before the civil court. Full stop. Having considered the facts and circumstances of the case, we of the view that the dispute is purely civil in nature, and as such, the High Court has rightly granted protection to the respondent number 2, since the petitioner himself wants that the condition of deposit may prejudice his rights. We accordingly set aside that condition and direct that the interim protection granted by the High Court to continue till further orders.
Anticipatory bail.
Anticipatory bail. Final order?
Final.
One more
Fine.
sentence.
Wait a minute, Mr. Counsel.
Yes. The order granting relief of interim protection or anticipatory bail will remain as it is.
My lord, may I only request? My lord, only my humble suggestions that this may affect my only suit pending before the civil court. My
That's
lord.
what we have said.
Condition may be as it is, my lord. We humbly request this honorable court, my lord. Condition imposed by the honorable High Court. We only say it may be made clear that no prejudice, no trial court shall not be just.
All right, thank you very much. Next case.
One more simple matter. 4 or 5 times had attacked upon the field. So may kindly be marked for security and so.
Next case. Go and apply that.
In 15, your lordship, we are filing an SLP against the main accused, your lordships.
Yes.
The lordship will have it after 2 weeks.
Milords, may I only
I was instructed, I was told to take instructions, your lordships.
Yes.
Milords, may I only say this, Milords, that Milords, criminal antecedent may not be the only factor. I have been in custody for 2 years, Milords. Delay in trial is also a factor. Many terms.
One more accused, Chhattis, or what is the name? Is he in custody?
He was
So
also
the
released.
accused, when? Where is the order?
Yes, the order is there, Milords.
Let's see.
Yes, Milords.
So you have to come in.
I'm filing SLP, your lordship.
Where is the order,
within 2
please show?
Plus page 71 and 72, annexure P10.
Chhattis Tiwari, yes. He has also got antecedents.
Yes, as per the case diary, 3 cases, Milords. He also has 3 cases.
He is filing SLP.
SLP, I'm filing SLP against all the accused persons, your lordship.
You attempt to loot by firing.
Likhie, then counsel for the respondent state of the Bihar states that the co-accused who have been granted bail by the High Court, and that against the order of the High Court granting bail to the co-accused. Jagdish Tiwari? Chhattis Tiwari?
Yes.
You are Artalis Tiwari? No. Chhattis Tiwari. The state is preferring a special leave petition.
Even against.
Let this matter be listed in July 2025.
Dhananjay Tiwari also.
Dhananjay
was not named in the FIR.
He's named in there.
Yes, many more.
That has
You are applying for his cancellation of
11 cases.
very well.
conspirator.
Satish Tiwari and Dhananjay Tiwari.
Dhananjay Mishra.
Mishra. Next.
To your lordship's last order, I have attempted that twice, my lords, on 7th of April and 8th of April.
Item number?
Item number 16, my lord.
16, my lord.
I have appeared before the investigating officer on 7th and 8th as directed by your lordships. I understand that I have been questioned for about 8 hours from 11 to 7 p.m. So, my lords, after your lordships first granted, my lord, interim protection to me on 31st of January, I have been called, only, my lord, thrice. And on each of the occasions, my lords, I have remained present.
No, earlier you had avoided.
No,
Yes,
my lords,
yes.
that is, my lords, please see what my learned, let me just address your lordships on that. My learned friend had relied on some correspondence relating to, my lords, in December and prior to that. What they were doing, my lord, they were hounding, my lord, my son, who is undergoing, he's a medical student undergoing psychiatric treatment. He was also in the midst of examinations. And what the reason was for summoning my son. Your lordship will recall, this is the matter where 3 doctors, my lords, we were 3 doctors, 2 of them have, after 3 years of this report, suddenly said that I forced her to them to sign this. For 3 years, my lord, they were under a Hippocratic oath themselves. What answer do they have to falsify the report? And, my lord, they don't do anything against those doctors. In fact, their statements are being used against me. Now, there, my lords, there is a 3rd doctor that has emerged, a cardiologist, who says even the day before I was appointed by the court and they asked for me to be appointed, I did not volunteer my services. As superintendent of the hospital, they asked for me. Now, my lords, that the cardiologist says in their, my lord, they've extracted it, that even the day before I was appointed, that I coerced him to file something. All this comes, my lord, 3 medical doctors are giving evidence, giving statements after 3 years of the incident. It's very serious, my lord, because this complainant is now in a position of great power. So, my lords, please take that into, and my lords, on the report.
He was not in power, so he was.
My lord, that is that whether according, so I let me address your lordships on the report. I was superintendent, my lords, I'm a 65-year-old gynecologist. That is my area of specialization. Now, my lords, when the complainant was brought there, my lords, it is on record. What is the High Court hold against me? That we did not, my lords, there was in the little, one of the little toes on one foot, there was a fracture which was not seen in the X-ray. And according to them, that we instructed them not to take that X-ray. Now, my lord, the whole procedure has been videographed as per orders of the court. They would have the videography. 1. 2, my lords, please see, it went to the radiology department. The radiology department's independent reports are on record. So, my lords, I am not a radiologist that when you send a patient that, look, his foot should be X-rayed. My lords, I am not there to say that please this toe and that toe and not this toe and not that toe. So I don't see how, my lords, when you take an X-ray of a foot, you can exclude everything else.
Can I show those toes to your?
And I have said, my lords, edema, discoloration, I have stated.
Can I show those minor injuries, Lord, and that scratch on the toe for a moment? Please come to PDF.
No, we have already seen all that.
Lord, my Lord Justice Karol was not in the bench.
Yes.
Lord, 213, Lord, just 213. I want to show your Lordship on 213 for my satisfaction.
I would appear as long as
PDF 213, Lord, I'm going to tell your Lordship how a petitioner who takes a contradictory stand in the pleading before your Lordships then recants in the 161, Lord, this in the examination for police, that's the conduct of the petitioner. I'm going to show your Lordship what she's doing. Please see, Lord, PDF 213, Lord. It's additional documents, page 7. My Lord, we just have page 7. And Lord, this is additional documents, ma'am. IA 41441. filed by the complainant.
You are referring to counter affidavit?
No, Lord, this is an IA filed by the complainant.
And by complaint.
These are the photographs placed, these are the photographs outside the magistrate's court when he is produced. Next morning, after the
IA 41441.
Yes.
State is relying on the complainants, my lord.
These are photographs, these are records which have been before the Honorable Supreme Court. Lord, your Lordships recall this, that matter where the earlier round came before your Lordships. Lordships directed he go to Army Hospital. Army Hospital affirmed the injuries. This is the lady who was the...
Mr. Luthra.
Yes, ma'am.
Answer one question.
Yes, ma'am.
How much is the gap between the so-called incident of custodial torture and the FIR?
Lord, I tell your Lordship, Lord, and I will explain, Lord. Next day,
Tell us mathematically what is
Lord,
the gap.
Lord, there is a gap. It came later.
How much? Years? How many years? 3 years.
About 3 years, Lord. But I'll leave that. The only thing I will leave your Lordship with one
What
thought.
prevented you from filing the FIR?
Lord, that's he'll have to answer. Not me. I'm the state.
You are the state. You will be the first person. Even in the FIR, it is required to mention.
My Lord, may I just say this?
Then
Lord,
you are opposing.
I'll give your Lordship the answer. I'll give your Lord.
When you are opposing the prayers.
I'll give your Lordship the answer. I'll give your Lordship. Not the police officer concerned was the one who.
You may as well sit down. Let him answer then.
Lord, can I just respond to that?
Yes, all right.
Since your Lordship said, Lord, why there was a
You
deal.
just now passed on the buck to him. So
Lord,
ask him.
Lord, please do. But please let me answer one thing. Lord, the police officer in question, who was the one who carried out this torture, was the one in whose custody he was.
Mr. Luthra, he was released on bail in how many days?
Lord, may I just say this? I'll leave
Please answer the questions, please.
Yes, of course, Lord.
Yes, in how
Lord,
many
but
days was a complainant released on bail?
Lord, he was released by your Lordship's court, Lord.
While the custody period was going on, police custody or so on, right? That was in 21.
20.
What has happened to Lalita Kumari? What has happened to Saki Rivasu? What has happened to 200? What has happened to 156.3?
I will leave your Lordship only with this, Lord. The next day itself, the magistrate notes the injuries. Please see the magistrate order.
We understand. But what was your case?
Not the magistrate, not the injuries are before the magistrate, not your Lordship.
We are asking you, what was your case? Injuries
Not matter was before your Lordship's court. There is a contempt pending against her in the High Court. I understand what is falling from your Lordship, Lord. I understand. But not when the law regulators become the lawbreakers, not things will become a problem. That is the reason your Lordship dismissed the police officer's petition, Lord. Did the police officer come to your Lordship dismissed that?
All right, clear.
Lord, may I just take 2 minutes? Not show you two things. I'll leave 2 minutes.
Master Lich, already.
Abhi to there was.
आपका एक ही argument है, Mr. Luthra.
No, there was
पहाड़ को खा जाए, क्या करेंगे?
Rapid gunfire which I was trying to face, and obviously unsuccessfully.
My brother has a lot of questions to ask. This side, right side. Only left side you are facing. Fire is not open yet.
Not my job is to face your Lordships and learn. But allow me 2 minutes. 2 minutes, not just 2 minutes. Lord, may I just take 2 minutes and show you one thing?
Let me.
Lord, just one thing.
He will continue to cooperate in the investigation.
Lord, one sheet.
And he also continue to cooperate in the trial.
On cooperation, may I just point this out? Then your Lordship may decide just on cooperation. Just see this.
Luthra, what are you going to extract from her, please?
My Lord, just allow me a moment.
These are all hospital records. What will you please tell us? As a lawyer having practiced on the criminal side for 3 decades almost, tell us please.
My Lord,
what will your police officer extract from her?
Lord, may I just say this?
You also use the same technique.
No, Lord. Not at all. Not at all. Just see this one sheet. Lord, just see this one sheet. Just see this one sheet. Now, Lord, her whole case has been of political vendetta. Your Lordship has noted that. That is the basis that my husband was a functionary. Please see in pleadings. Husband of petitioner is a member of YSR Congress, thus making evident petitioner selectively targeted and subjected to harassment solely on the account of his political affiliation. B is the same, C is the same. Now please come to the statement she makes. He practiced as a lawyer, also worked in legal cell. That is the first statement.
What is it got to do with the case she is facing?
My Lord, all I am saying is when a person sets up, I'm sorry, with respect to it, if a person sets up a case of political...
Again we'll
all right.
Same order. Next case. CRPC to you.
My Lord, on interrogation, she is making a mockery, not even giving answers in line with the pleadings.
Then you compel her to give an answer that you want.
My Lord, no. If not, she's required, duty bound by law to give a truthful answer.
Then there are still consequences.
All right, Lord.
Yes.
All right, thank you.
But your lordship will give the direction for cooperation.
Yes, yes, that is standard.
May it please the lordship. My lord, in this case, 7 persons were nominated in the FIR. They said we entered the house and then role of firing was attributed to me. Then during investigation, my participation was found false. The police recorded statements of several independent persons and so was the first, they moved an application after these statements of 2 witnesses were recorded. The first application was rejected as the independent witnesses and the statement of doctor because only abrasions were found. So that first application was rejected, against which they preferred a revision and then revision, the Honorable High Court remanded back, my lords. Now I've again been summoned under 319. And the evidence which was collected during investigation, I know there are certain, I mean, in Hardeep Singh it says, but there's another judgment where Brijen Singh, which we have cited, where they say that, I mean, his participation was found false. Since the independent witnesses were not examined, let some more witnesses be examined and then the court can...
What is to be seen at the stage of 319 evidence?
All right, Mr. Bhargav, thank you. Mr. Bhargav is master in criminal law. Yes, he understands everything.
But some, maybe that is bail may be disposed of expeditiously or some.
Apply for bail, you'll get it.
Because this is the case where apparently.
Yes.
Not item 48, not.
Yes.
Lord,
Did you say never involved?
Because Lord, I filed a case against those people as well.
Big scam.
But Lord, if you see the Lord, the cyber complaint report and as well as my cyber complaint, Lord, I have specifically mentioned that how my father, who is an illiterate, was made to download these files, APK, and then it was transferred. And whatever amount was left, I surrendered to the bank saying that I showed my...
That is your defense, you will not consider it as mistake, no? Not a case for bail. Anticipatory will that.
Anticipatory.
Dismissed. Next. Yes.
Your Lordship, I am merely 19 years old, Your Lordship, and it is very important to highlight firstly here that I attained the age of majority 8 months ago. And at the time of incident, Your Lordship, I was freshly a major having attained the age of 19 years, Your Lordship. And I am behind the bars since 1.5 years facing incarceration on mere assertion of the of my name by the victim, that too in the supplementary statement. My name is nowhere in the FIR, nowhere in the main statement of the victim that was taken on the date.
What is returnable within 4 weeks? What do you want?
Yes, Your Lordship.
We have issued notice.
Obliged, Your Lordship.
You argued well. You argued well.
Thank you, sir.
Yes.
Lordship, this is a matter where the mother has taken a 12-year-old child out of custody of the father. Originally, she was based in Australia. She returned to India on 24th when the father was not present at his residence, and she's taken the child out of his home. Basically, the apprehension is that she's taken the passport of the child with her, where we are apprehending that she'll go to Australia, where she's
define a habeas corpus?
Lordship, because we had no contact with the child. She was taken.
Custody, she's the mother.
She's the mother. I agree, Lordship, but
guardian.
I agree, but she was not in the country for almost 7-8 years. The child was never in the custody. He was normal residence with the father only, Lordship.
Dismissed. Dismissed, sir. Next.
Against conviction. The trial court acquitted.
Appeal against conviction.
There's an appeal against conviction. The trial court acquitted me. The appellate court convicted me on 3 grounds.
Yes.
That is section 353, 506 and section 3 of the PDPP Act. That is the Destruction of Public Property Act. Now, 4 main grounds. May I first put on the grounds and then I seek permission to substantiate. One, there is no recovery of the allegation against me is that there was a crowd which had blocked the road seeking repoll of the deputy sarpanch election in 2005.
In what manner?
Sorry,
in what manner?
The crowd.
What was the way in which you asked the officers to go for repoll?
That is the allegation against me.
There are 2 responsible, one RS officer and one IS officer.
IS.
Spoken against you.
Yes.
Okay, now you carry on.
Yes. But
एंट्री ऑर्डर दिया हमने इसको रिकॉल क्यों नहीं करती?
हमने एंट्री ऑर्डर दिया है?
कहाँ है सर?
वो इसके रिजल्ट से वो सेंटर दे दिया है।
हाँ बिल्कुल सर।
अभी डिस्मिस कर दिया ना इसको।
No.
This is ridiculous.
Kindly consider
a person having 15 antecedents.
No, that
goes
is
to the poll.
Just
puts
one.
a gun at the gunpoint.
You have no right to assault a government servant.
I did not assault at all, That is my case. Your Lordship, no, in criminal law, there are broadly only 2 defenses. One, the crime did not happen. Second, the crime may or may not have happened. I did not commit it. My case is, I did not commit the crime at all. The crime never happened. Please, Your Lordship, put a very pertinent query to me.
The officers had some score to settle with you. That is why they have spoken against you. That's why.
Kindly consider this.
The collector, the Vikram Yashwant, gave the report of the incident immediately wherein your name was there. Your argument is delayed.
He says
no
that
recovery. How long were you absconding, please?
Kindly see.
How long were you absconding?
I was not
3 years.
absconding at all.
3 years.
Kindly consider.
No policeman dare put a hand on you.
Only page 115.
Saxena, unfortunately, you are before a court which knows the hard facts with greater reality than you do.
That is, my honor to be for your Lordships. Kindly, Justice Vikram Nath's query, at page 115.
Yes.
That appellate court's order at page 115, your Lordship's query, regarding 15 antecedents. Because, the Honorable High Court seems
there
to
are
be
2
swayed.
convictions also apart from this one.
No, including this one. Including this one, there is one more only. Please, page 115 for a moment. Regarding your Lordship's query, that is very pertinent. I'm so sorry, not 115, para 120, page 120.
Mr. Saxena,
The list of 15 cases which they say, please have page 120 for a moment. From the appellate court order, which convicts me, trial court acquitted me. Please have page 120 for a moment.
Revision has been dismissed.
Revision has been dismissed. Yes, please have page 120 for a moment, because this is one of the major factors which has swayed the High Court to dismiss my revision petition. That there are 15 cases. Please have page 120.
Are you required to make a declaration while you are contesting the?
I made that declaration. There are no 15 cases at all.
Public document.
There are no 15 cases.
All right.
Please have page 120 for a moment. There's the appellate court and the revision court, they weighed heavily on this factor that there are 15 antecedents against. Yes, kindly consider this. My second argument now,
direct evidence against you or
there
not?
Is no evidence. Please have
no evidence.
Except the complainant's statement.
No,
there are other witnesses. There are other witnesses.
Yes. 3 of them have.
One is the
There
Tehsildar.
was no camera broken.
No, the Tehsildar and the IAS probationer.
Revolver on the ear temple of the learned SGM. Now consider this. There is no recovery of any revolver. For the PTPP Act, your Lordships, no malice, and for 353, The police has to recover, my lords. There was no recovery of any revolver. One.
Who are you?
Second, sorry, my lords.
Who are you? What is your status?
Now, my lords.
Then and now?
Then, my lords, I was a student
Just
leader.
a student leader.
Yes, so my lords, I could not have influence, my lords. This is completely wrong.
After
Second,
how
my
many
lords.
months were you arrested in this case, by the way?
What do you do now?
My lords, now I'm
Sitting MLA, my lords.
I'm a sitting MLA now, my lords. I'm representing.
Board or minister also?
No, not.
After the minister. After the
He's trying to gain experience.
No, this is my second time, my lords. I was a minister earlier. I was a MLA earlier.
After this incident, 9 more cases, 5 of them against attacks on public servants. I think that's the specialization.
But there's nothing.
Attack the public servants.
This is all in the thin air. After the incident, my lords, at the time of commission of the crime. So kindly consider this, my lords. I'll kindly consider this. There is, my lords. Consider my another argument.
Only till today.
Okay.
Your Lordship, consider my argument, my lords.
The exemption was only till today.
Till today only.
Yes.
Kindly consider this, my lords. The allegation is that I took out the videographer's cassette and I broke it down and I burnt it. There is no videography camera recovered. There is no CD recovered. There is no cassette recovered. There is no public property which is recovered for the purposes of the PDPP Act. Now, I've been convicted under Section 3 of the PDPP Act and I've been sentenced for 3 years, my lords. Please have, my lords, how the appellate court also, my lords, appreciates it. Please have, my lords, page 115, how they have, my lords, appreciated it at para 34, page 115. So one by one, they have dealt with all the charges which were framed against me. So charges under, your Lordship will see para 34, charges under 332, not made out. Then, my lords, page 116, para 35, 353, they say that there was use of criminal force. Now, for criminal force, my lords, there has to be an instrument which is being used. The SDM, my lords, sends a statement. Sorry, my lords.
The SDM makes a statement.
The SDM gives a statement that I used a revolver. There is no revolver.
That's right. You would have retained the revolver for 3 years.
My lords, the case beyond reasonable doubt.
Mr. Saxena, where there is ocular evidence, weapon need not be recovered. You don't tell us, please.
Well, let's kindly consider. No weapon used, no CD found under the. Now, kindly consider Section 392, robbery.
The elected representatives need to discipline themselves, start behaving in better manner. This is one of those rare cases where somebody has been convicted. Otherwise, you do anything and get away with it without any action against you.
I completely, my lords, follow your lordship, my lords, that elected representatives have to follow a certain. But in this case, my lords, kindly consider. In this case, my lords, I did not commit the crime at all. This is completely exaggerated.
Constituency and the country, but also the public servants. You treat them like dirt. Correct?
And the
But in this
expediency
case,
with which
you
the
must
matter has
have
come
learned
up.
to do it.
The judgment of the High Court is 1st May. Exemption is filed, listed, SLP to this court.
No, kindly consider this, my lords.
Dismissed.
No, kindly consider this, my lords. On the sentencing, at least, my lords, lordships may
Lawyers to enhance it. Can be enhanced, no.
No, I've already been given maximum under 353.
That's all right.
So we can make the sentences consequent
Instead of
concurrent.
Your lordship may kindly consider this, my lord. This is, I understand, my lord, this is a hard case, but kindly consider there's a reversal of acquittal by the Honorable, my lord, the appellate court. The principles of, my lord, reversal of acquittal also have not been followed in the appellate court's judgment. And this revision petition, my lord.
Don't compel us. Read the trial court's judgment page first.
Yes, my lord.
See who has passed the order. Get your answer there.
I get that answer, my lord.
Then that's all.
I may not go
Thank
on
you.
that, my lord, but kindly consider.
No, we know better with the experience. Don't tell us. Don't compel us.
Your lordship may then, my lords, your lordship granted me exemption from surrendering till today. My lords, I'm a sitting, my lords, MLA. Your lordships may kindly consider, because I'm an elected representative. There are, my lords, certain things which I have, my lords, managed in the constituency. Your lordships may extend it for, my lords, at least for some time, my lords, so that I can, my lords, make some arrangements, etc.
No. Well,
and the Honorable High Court directed me to.
He has 27 cases against him, my lords. The 15 was before he even indulged in this. After this case, 12 more cases.
We are not inclined to interfere with the order. Petition is accordingly dismissed. However, on the request of Mr. Navid Saxena, let it count for the petitioner. We grant 2 weeks' time to the petitioner to surrender. In case the petitioner does not surrender within 2 weeks from today, the state would be at liberty to take all such measures, take him into custody to serve out the remaining sentence.
I am obliged.
Great. I still feel, my lords, your lordship saw the first page of the trial court's order, my lords.
Yes, so Saxena, please don't force us to
I'm so great.
make comments now.
I'm so great.
Yes. Item 28. Yes.
So, death case, my lord.
Yes.
Yes, please. The incident, unfortunate incident, and murder of a 3-year-old girl is the conviction is on that. Only circumstantial evidence, one accused, have been convicted by the trial court and the high court and sentenced to death. Now, before I get into the specifics of the evidence, my lord, I'll just tell your lordships what the incident is. On 30th September 2013 in the morning, a small child, 3-year-old child, at about 10:30 in the morning, the father, PW1, went to work, came back at 10:45, and the child was found to be missing. So the father and mother are separated. The grandmother is there. Then the father looks around everywhere, could not find the child, and he went to the neighborhood, asked people. Some of them apparently told him that the girl was playing. They saw the girl playing with a dog in the road, etc. Finally, they could not find the child. At 11 p.m. at night on 30th September, a complaint was lodged of a missing child, and the FIR was lodged at 11 p.m. at night on 30th September. Investigation started. On 1st October morning, the police came to conduct a search panchnama and with 2 witnesses. I'm just giving you a broad overview. I'll come to the specifics in a minute, my lord. And on 1st October, the next day, the complainant took the police to various places in the locality where the people apparently had told her the child was there. And they say that PW9 at that time, PW9 said that they saw the child, PW13 said that PW14 said that they saw the child, etc., etc. But they could not find the child. Then the body of the child was recovered the next day on 2nd October 2013. And the body was found in a pond. And they recovered the dead body, conducted postmortem, etc. Now, then on 3rd October, another IO took over the investigation. And my lord, also I must say, this locality is what is called a watchman chawl. There are a lot of watchmen in the locality who were living there. So it appears from the investigation, it appears from the evidence. I'll take your lordship to the evidence in a minute. It appears that on 2nd October, around 30 watchmen in the locality, not me, I'm also a watchman, were rounded up and taken to the police station. And it also appears from the record that all 30 watchmen, they had taken samples. It's come out in evidence of some of the watchmen itself. They had taken samples of nail, hair, semen, all samples taken. And lordship, note the date. On 14th October, they had sent these samples to FSM for examination of all 30. So, and that
samples were taken on?
The witnesses say 2nd October medical samples were taken. The samples were sent on 14th October. Now I'm talking about 2nd October. And on 3rd October, the next day, the prosecution says that they took 161 statements of some witnesses who were in the locality itself. Some of these witnesses were mentioned in the spot panchnama itself on 30th September, but 161 is recorded only on 3rd October. And the investigating officer says, based on the 161 statements, etc., I was arrested on 3rd October, 8 p.m. On 3rd October, I am arrested. Now, I'll just straight away come to what are the circumstances against me that the
Yes.
prosecution is relying on, so that Lordship get an idea. I have to meet that. Lordship may note, first, there is a witness, PW9. He is also another watchman. Lordship may note that. PW9, Dipendra Shukla is his name. He deposes that at about 11:30 a.m., he saw the girl along with the dog in the road. Girl and the dog. Now, the same PW9 deposes that he says he saw the girl at 11:30 a.m. PW9 says at 1 p.m. he saw me coming out from some bushes, coming out from the bushes.
With mud and water on your feet.
With mud on my feet. PW9 says that. So 11:30 he saw the girl and the dog, and 1 p.m. he says he saw me coming out from the bushes. This is PW9. I'll read it now. I'm just telling your Lordship right now what are the circumstances against me. Now, PW14, a person called Pradeep Rawat. He also was one of the persons in the spot Panchnama. PW1 says he asked PW14. PW14 says at 12 noon, he sees the accused, he sees the 12:10 p.m. He sees me, the girl, and the dog. Now, he is the only person, Lordship may take it, he is the only person who talks about me and the girl being seen together, 12:10 p.m. Now, two things I just...
What is the name of PW14?
Pradeep Rawat, Pradeep Kumar Rawat, PW14.
He is also a chowkidar.
Chowkidar. Watch. Yes. Now, PW14, I would like at this stage to say two points. One, PW14 in the spot Panchnama, I'll read the spot Panchnama on 1st October, the next day. The PW1 takes the police, says this person told me, etc. He talks about PW14 at that time. He doesn't say at that time that PW14 said anything about me. Point number one. Point number two, in the 164 statement of PW14, what PW14 says is he saw the accused standing there. Nothing about the girl or the dog there in his 164 statement. Please note that. Now, the next witness, my lord, is PW15. Yes, PW15 was Sanjay Kumar Rao, the brother of PW14. Now, he is also a watchman. Just assume some importance. Lordship may kindly note. PW15. So, Lordship may take it. I've right now told you Lordship about PW9, PW14. Now, I'm talking about 15. Yes. 15, who is the brother of PW14. He is also a watchman. All of them live in that locality. It's called a chawl. It's like a densely populated rooms after rooms.
What is his name?
Sanjay Kumar Rawat, brother of PW14. Lordship may note that brother of PW14. I'll tell you Lordships in a minute why I'm saying that. What he says is when he comes back for lunch at about 1 p.m., he saw this dog tied to his room, PW15's room, which PW14 also says.
1:10 p.m. 1 o'clock.
1 p.m. So his evidence is when he came, he saw the dog being tied to my house, my room. No, it's not a house, it's a room. My room. Yeah, PW15's room. Now, this assumes some significance because I will develop the argument in a minute, but I'll tell you why I'm saying this brother and this. PW15, I'll show the map. PW15's room is here. Where the rape occurred is, according to prosecutor, the room is here. The dog is tied here. Now, if I can say that, the fundamental mistake which the High Court, one circumstance, the courts below were held against me is that they assume that this dog was tied in my house. My house, it's not. Even as per the prosecution case, that's not the case. So now this happens, this tide, etc., happens on 30th September. Lordship may note that. Then the next evidence, next witness is PW 17, Anil. He is the supervisor under whom I work. The supervisor of the watchman.
What is his name? Anil.
Anil. Anil Mahatam Singh. Anil Singh. Now,
When was his statement recorded?
yes, Mullah?
When was PW 17 statement recorded?
When was his statement recorded?
Immediately.
12/10, much after. 12th October. See, other two people, PW, I should have said that, a PW 14 and 15 statement recorded on 3rd October, PW 17 recorded on 12th October.
And PW 9?
3rd October.
3rd October.
Now he says he came back. He was not there, so he came back on 10th October.
14 and 15 recorded?
All third. 9, 14, 15 on 3rd October, 17 on 12th October. Now, PW 17's evidence is only for this limited purpose, Miller. What PW 17 says is this, that I came back, then I came back, and then I found that this PW accused is not come for duty. So my father also was working the same place as a watchman. So I asked the father, where is he? So he came back, he called, I told him, just call him and come back. Then he came and met me. I asked him, why aren't you coming for work? He said, "Main tension mein hu," is what he said in his chief examination. Prosecution declared him hostile and cross-examined him. In the cross-examination, it's extrajudicial confession. What cross-examination? And just tell me the words. And in the cross-examination, they say, आज ड्यूटी नहीं करूंगा, टेंशन में हूं, मेरे से गलती हुआ है, घर पे रहोगे तो टेंशन कम नहीं होगा, तुम काम पे आओ, he said. And so he was declared hostile because in the chief examination, he said, I did not come because my tension mein hu. So that is the purpose for which PW 17 is relied upon by the prosecution. Now it appears, now I can only, before I read the evidence, my lord, this incident occurred, the girl went missing unfortunately on 30th September. The police were investigating. They were in the dark and I don't know how, it doesn't, I guess watchman Chal, etc. They went there, got rounded up. These are all people not from the locality. These are all people from, this is in Maharashtra, the incident is in Maharashtra. They're all people, migrant workers from North India. They all came to Maharashtra. So they go to the Chal, round up 30 watchmen to take them to the police station, make them, get their samples. So I was arrested on 3rd October. On 14th October is when the samples of the other 30 has been sent. So even then, the police is not fully sure as to who. My sample is not sent then. My 14th.
Your samples must have been sent immediately after your arrest.
410.
Yes.
410. Yes. Now my samples are sent. Now the question arises: what is the FSL scientific evidence against me? These are the witnesses who rely on, who the prosecution relies on. Now, the recovery, that also I should tell a lordship, circumstances against me. Please note that I am arrested on 3rd October. By then, they know the locality, everything. The investigating officer in the charge sheet says, this room where I allegedly stay, there is nothing on evidence to show that I am the only person living there. These are 5-6 people living there together. Police, the investigating officer says that. Now, on 8th October, that is 5 days after my incident, they take me to the room in which I stay along with others. And recovery is, lordship may note the recovery, section 27 recovery. One is a lungi with blood. What the result of the FSL report, I'll tell you lordships in a minute. But what is recovered is lungi with blood, A, banyan, B, watchman uniform, shirt, trouser, belt,
everything. And 4, most importantly, Lordship may note that my shoe, this is 8th October, Lordship may please note, 30th September's incident, a shoe with mud on it. Where the shoe is mine, etc. But these are what recovered from there. They sent all this for FSL examination. What is the report, my lord? I'm not reading it, I'll just tell you, Lordship. The lungi with blood, the FSL report is, it says no grouping, no amplifiable DNA found, and it doesn't even say whether it's a human blood. So that is a FSL, the lungi with blood, nothing to identify me with the watchman uniform, etc. Nothing was found, so there's not sent for this thing. What was sent next was my shoe with mud, which is the circumstance being held against me. Lordship may kindly know what is that circumstance. 8 days later, they found a shoe, assuming that everything, that shoe is intact, just like that. I walked from that mud, came back, I kept that shoe just like that without even cleaning the shoe. Assume all that to be correct.
So on all the 3 clothes, lungi, banyan and uniform, there is nothing?
No.
Okay.
Even according to the...
There's nothing identified.
Yeah, but just to add one step further, even as per the prosecution, blood was there only on the lungi. So that lungi, they say that no amplifiable DNA, no grouping, and doesn't even say whether it's human blood. Other 2, there was no blood anywhere, nothing was there. Now shoe and mud is the one circumstance. Now, so they recovered it on 8th October. So if that, like I said, I'm repeating this, 8 days after the incident, the shoe which I allegedly wore while committing the offense is intact. I didn't even clean it. It's lying there with the mud. They take it, send it to FSL. What does the FSL reports? They also took some mud from where the pond, near where this, unfortunately, this body was found. They say that the mud on the shoe matches, tallies with the mud they took from the pond. And this is the most important circumstance which the prosecution relies against me. This FSL report says that mud tallies with my shoe. Yeah. Arrested on 3rd October. This recovery in a place where more than one person lives in a room on 8th October. And how they collected the pond. Now, this is not a place, I'll show you the map, my lord. This is not a place which is not in my locality. This is in my locality. I can walk. So I can understand. Now, normally, if you take, I'm assuming you take earth from the sand, mud from a place, there has to be some elimination. This mud is found only there. You take a mud next to my house and say that is different. That is not done. What they've done is took the mud from the pond, took the mud from the shoe, tallies, it is yours. That is the, even when brief me, I told them there has to be something more, but no, this is the only thing that has been held against me in the FSL report. Now, the investigating officer, there were 3. One registered the FIR, one conducted from 30th September to 2nd October. Third, from 3rd October onwards. Now, 30th September after I was arrested, 30th of September spot panchnama, I'll read that spot panchnama. They go and the PW1 says, PW1 told me, PW9 told me this, PW14 told me this, PW15 on 1st October, the morning 7:30. No one, these are all people, watchmen in the locality. And
how could the spot panchnama have been prepared on first when the body was recovered on which date? Second. What is the significance of the spot panchnama?
I should have said search panchnama. Search panchnama. I said spot. I should have said search panchnama. I'm sorry. Yes. Search panchnama. Yes. I stand corrected. Search panchnama. So on that day, the PW14, PW9, etc. was in the knowledge of the investigating officer. 161 statement recorded on 3rd October. Now, I can only try and develop a case. Now, what I submit is this. This is the room of PW15 Sanjay Rawat, in whose room the dog was tied. this Sanjay Rawat, PW 15, was called to the police station on 2nd October along with his brother PW 14, and their samples were taken. So in their mind, they are in the radar of the police. Dog was tied in front of PW 15's room, even according to him.
Who is the witness who says that where the dog was tied?
14 himself, the
14.
person himself. PW 14 and 15, both of them say that I found the dog tied in front of PW 15.
His room.
In his own room.
room.
And his brother says, I saw it tied in front of my brother's room. So the room where the rape occurred is right opposite. So these samples were taken on 2nd October. 161 is recorded the next day on 3rd October. So his PW 15's brother, PW 14 says, and 14 says, he's the only person who says he sees me and the girl and the deceased. And the dog. And the dog.
All right, now we understand. What about the forensic samples recovered from the room?
Yes.
What is the status there?
Nothing other than this mud.
Nothing at all.
Nothing other than this mud.
So what is the story? The crime was committed in your room.
Yes, ma'am.
Thereafter, you remove the dead body and throw it in the pond.
Crime is, according to the prosecution, is not committed in my room. Where this recovery took place is not where the crime took place, according to the
crime
prosecution.
scene is something somewhere else.
Room number 4 is my room. Room number 2, which is opposite PW 15's house, where the dog was tied, is where the alleged crime occurred.
So that's what we are asking you.
Yes.
From that room, what?
Yes. Now I'll tell you. From that room, they seized. Now that is not Section 27 recovery. That was recovered before my arrest. 310. Before my arrest. Before my arrest, so I won't call it recovery, seizure. I'll call it seizure.
Right.
So seizure from that room is, I'll tell your lordships, a gunny bag with blood. B, a purple t-shirt with blood. C, important, a Koba stone, a cement stone, which according to the prosecution, they sent saying Koba stone with blood. So 3, long hairs and short hairs. So these are the things that are recovered, seized. Now FSL report. FSL report regarding gunny bag with blood. Blood, it doesn't even say human blood, no amplifiable DNA, no grouping. Purple t-shirt with blood, they say human blood, no amplifiable DNA, no grouping. The hair, etc., nothing to identify, nothing to relate that hair to me. So yeah, thanks. Koba stone with blood is what the prosecution says. FSL report comes back, says this Koba stone does not have blood. So not even blood. Why they say is that death could have happened by banging her head against the stone, etc. But Koba stone, forget being linked to me, it says no blood at all. So these are the articles seized from the room where the alleged crime occurred. And
who was in possession of that room? Any witness comes forward? Says so?
Nothing. The evidence that has this PW, the room number 4, where the recovery occurred, is where I stay along with others. Because the categoric IO statement saying that there is nothing on evidence to show that I am the only one staying. This is a chawl. Everybody lives there. It's like it's a densely populated chawl. Now, in this context, the major circumstance against me to convict me and to sentence me for death is the shoe and the mud. That is the only thing which the prosecution relies on to link me to the crime.
And also last scene.
I'm saying,
and alleged confession.
Yes.
Alleged.
No. Yeah, I'll paraphrase it. The only scientific evidence, quote unquote, to link me is the shoe with the mud. The evidence against me is PW 14's evidence, who says he saw me and the girl at 12:10 p.m. and PW 9, who says that he saw the girl at 11:30 a.m. and he saw me coming out of the bushes at 1:10 p.m. Now, and of course, like your lordships rightly put it me, the PW 17 who says galti ho gaya on 12th October when he made a statement. Now, in this context, my lord, can I take your lordships to the evidence of PW 9, 14, the short, if you're, but this is all. I think I've unless I missed something, but this is all that is there against me. Yes. Lordship may straight away come. First, can I start with the 1st October? Chronologically, I'll go. The search Panchnama. Lordship may 1/5. There is a, I don't know, Lordship using soft. There is a compilation trial court records. I don't know whether lots. The printed also is given. Court must.
Compilation trial court.
Compilation TCR is the name of the document.
Yes, yes.
Even hard copy
By
also.
Advocate Fawzia Shakil.
Yes, sir.
Yes.
Yes. Let me see.
The last one document, sir. 8th number.
Yes. Page, the running 153. It's bookmarked, my lord. If it Lordship is in a soft copy.
Is it so?
Yes, my lord. It is it bookmarked?
No, it's not bookmark. Yes, it is.
It is.
Sorry.
Yes.
We have the testimonies first.
Yes, my lord. Is that?
No. Rather than the Panchnama.
Yes.
Testimony of PW9.
I can start with you. I thought I'll start with. I can. And then I thought can I just show this quickly? Then can I come to the subject of Lordship? Yes, my lord. Lordship, may kindly see this. Page 153, my lord.
Starts from 149.
My lord,
That's Marathi.
Yes, my lord. Fortunately, it's Marathi, my lord. Otherwise, Lordship would have told me to read in Hindi. Then I would have struggled.
Definitely.
No, I can read, my lord, but it's struggle.
No, you can always learn.
Yes, my lord. No, in Kerala, we learn, my lord. We learn from class 5 to class 10, we learn Hindi. So
it's a matter of pride.
Yes, but handwritten is the problem. Type.
Yeah, yeah. You're right.
Yes. Page 153, my lord. May I just read, my lord? The two punch witnesses, Lordship, I'm not going to read them, but Lordship will note against their name. Devidas is PW5 and Uma Shankar is PW3. Lordship may note that and nothing turns on them. We, the above mentioned Panchas on this day, 110 at 7:30 were called by so-and-so police station, Assistant Inspector Lokre at Banjari Chawl so-and-so and explained the brief facts. Sorry, 153, my lord.
Yes.
My lord got that, my lord?
Yes.
Under section 363 and requested us the above mentioned Panchas to carry out the Panchnama place of incident where the kidnapped girl by name so-and-so, a name should not have been there, in the said offense were last seen in the place from where she was kidnapped and she was there before we Pancha so-and-so. Now, my lord, at the said place, that Manoj Kumar is the father of PW1. A person is present along with Assistant Police Inspector Lokare. Assistant Police Inspector made acquaintance of the said person with us that he was a complainant in the aforesaid offense and father of the kidnapped girl Helen. When we Panchas asked name and address to him, he told his name as Manoj Bhaskar Sadar. Watch me note PW1. That is PW1.
The complainant.
The complainant. Girl's father. Residing at so-and-so. He told that he shows us the way by which his kidnapped daughter went on to the date 39 and where she was seen at last and we should follow him, and by pointing finger, he showed room in the house in which the victim girl was. The said,
what does this indicate? That room number 2.
He shows us the way yes, and we should follow him. He showed the room in the house in which the victim girl was. No,
what is
that is his house.
His own house.
His own house, where the father.
That's probably a translation error.
Yes, madam.
Yes.
The said room is admission so-and-so feet in width and length. That is the father's house.
Yeah, yeah.
In the west side is open. Thereafter, now the sentence. Complainant took us, Panchas and the police by Kacha Road and brought us near the Bricklin, located at a distance about 300 meters on the north side of the said room, and told that on the date 39 at around 10:45, a person by name Prem Shankar Jayashankar Gupta, not examined, aged 21 years, had seen his daughter playing with the dog. Thereafter, the complainant brought us Panchas and police in front of Ashapura grocery shop situated at the distance of 200 meters north side and told the owner, the said Ashapura, Shri Raju Pukra Chowdhury, not examined. That I'm just, as a matter of fact, I'm saying that on 39 at around 11 hours in the morning, he had seen the said victim girl playing with the dog. Similarly, even some people working at the said place told him that they had seen her playing with the dog. Nobody of that has been examined. Thereafter, the complainant took us Panchas and the police and brought us near transit camp consisting of a floor situated at the distance of about 100 meters on east side of the said Ashapuri grocery shop, and pointing finger toward the heap of soil in the open ground on the south side, told that a person by name Jaybeen Channappa Kamble, not examined, residing in the said camp, and some other people told him on the date around 11:15 they had seen his daughter at the said place. Thereafter, the complainant took us Panchas and the police and brought us in front of a room situated in so-and-so chawl situated at the distance of 100 meters on the east side of the said transit camp, and told that, please note, that is PW9, Shri Dipendra Kumar Dhirendra Shukla, PW9 told him that on the date 39 at around 12 noon, he had seen his daughter while going alongside a dog in front of his room. Thereafter, nothing about me. Thereafter, the complainant took us, Panchas and the police and brought us near the window of the third number room from the east side in the chawl, south side of the room. And on a date when he was tracing out his daughter so-and-so, he saw someone had tied their domestic dog who was with daughter Shubhangi on the iron rod of the said window. On observing the said window and the wall thereunder by us, Panchas and police, the marks of scratching on below windows are seen. Thereafter, the complainant took us, Panchas and the police and brought us in the open ground situated distance over 30 foot on east side from the window. In the said date, around 12:15, a person by name Pradeep Kumar Raut, please note, PW14, and other people had seen his daughter so-and-so playing in the said ground. Now, that's all. Now, why I'm saying is PW14 and PW9 were referred to, but no reference to me. 9 had said in his, I come to the evidence now, like Lordship want, now I'm going to read 9 and 14, my lord. Now, Lordship, I'll read the evidence and then come to the argument, my lord. PW9, Lordship may come the same volume, 211. My lord. Yes. This I'll just read fully, my lord. It's important. In the year 2013, 211. 211. Will I got that? Justice now?
Yes.
Yes. In the year 2013, I was working as a watchman in Maharashtra Security at Lalani Residency, as well as I was residing in transit camp, which was in front of Unnati Woods. After leaving 2 to 3 lines of the house, 15 to 20 watchmen were residing there. I did not know the accused Ramtirath Gaud, but I used to identify him by his face when he was proceeding by that road. He was also residing in the same chawl along with his father, brother, and other 4 to 5 people. That's a typo, it's 39, it's not 39.
Yes.
On 39-13, near about 11:30 to 12, I was taking lunch by keeping open door of my house. That time, one girl having aged 2.5 to 3 years was proceeding by that road by taking one dog with her. I had seen that girl. Thereafter, near about 1 p.m., myself and my father, it should be actually went out of the house for our personal work. That time, I had seen that dog was wandering on the road, but said small girl was not with that dog. Immediately, I had seen accused Ramtirath Gaud who was coming from the side of the bushes. That time, he was on the uniform of watchman. Said bushes are near the Unnati Woods. Thereafter, I went for my work. Near about 4 p.m., please see this, when I came to my house, that time I came to know people are taking searching one small girl. They were shown photograph of that girl to me and identified her and told her that I had seen that girl in the afternoon time. Thereafter, I came to know the name of the girl was so-and-so. That on 2:10, dead body of the girl was found. I had narrated an entire incident before the police, which I had seen. That is on 3rd October. Accordingly, police recorded my statement. If accused shown to me, I can identify him. Now accused shown before video conferencing, he is the same. Now please see the cross-examination. I have not produced any documentary evidence before the police to show where I was working. So-and-so police station at a distance of 20 minutes from my house. On 39, police inquired with me, but on that day, they did not record my statement. Please see that. As well as on 2:10, police visited the incident spot, but on that day also, they did not record my statement. In the transit camp, about 25 to 30 North Indian people were residing and they're doing the work of watchmen. Police, please see this, Milord. Police called these people for inquiry. Police did not record the statement of family members. Now, I'll just pause here for a minute. When your lordships come to the evidence of PW 14 and 15, they say that police called all of us, and for them, police took the sample also. PW 9 sample was not taken. 14 and 15 sample were taken. Now, it is next page, my lord. It is not true to say that I'm deposing false that on 39 at about 12 o'clock when I was taking lunch that time, I had seen a girl having 2.5 to 3 years with a dog. I had stated before the police that by keeping open the door of my house, I had taken the lunch, but it is not mentioned in my statement. There's some contradiction. I'll leave it at that. I cannot assign any reason about it. In 161, he did not say door was open when he saw, but it is only true to say that I'm deposing false. At about 1 p.m., I had seen only the dog and girl a dog and girl was not accompanied with that dog. It is not true to say that I'm deposing false that I'd seen the accused when he was coming from the bushes. It is not true to say that relevant time accused so-and-so was present on his duty. It is not true to say that I'm deposing false that about 4 p.m. family members of that girl was taking search of her, and when they had shown photograph to me, I identified her and told them that I'd seen that girl with the dog. It is not true to say that I'm deposing false that on 2:10 dead body of that girl was found in the pond. I do not know the full name of the accused in native place. Police were not called me in Thane jail for identification pursuit. Now please see this, bro. We used to remain present in the police station for whole day. Police called 25 to 30 watchmen on suspicious grounds in the police station. It is not true to say that police forcefully cited my name as a witness. It is not true to say that today I'm deposing false against the accused. The only yes. Yes. I was at 213, man. The last two lines. The para 5, page 213, the last 4 lines.
Yes. Ah, you are read this.
Yes. I read the last 4 lines. I just want to emphasize one fact. So there, what PW9 is saying that police
for 25-30 watchmen
on the ground of suspicion. So all of them at that time were in the radar of investigation. And some of them samples also were taken, which Lordship see in PW 14 and 15. And they are the ones who depot the evidence against me is one of those watchmen who were called for investigation, samples taken, etc. Now, Lordship, may please straight away.
Sorry, only one query.
Yes, madam.
Page 212, he says that I identified the girl with the photograph. Can you just give us that date?
Yes, madam. Where Lordship is reading where? Okay, yes, madam.
3.
Accordingly, paragraph 3.
They were shown photographs.
212 near about 4 p.m.
4 p.m. and I came to know people are taking, they were that is on 30th itself. 30th. Yes. Now, Lordship may kindly come to PW 14 to 61, the same compilation, page 261. Now, PW 14, before I read, Lordship may note, this is the only witness who's talked about my presence along with the accused and one other watchman. Now, in the year 261, yes. In the year 2013, I was residing near so-and-so. I was doing work. That time I was working at Unnati Woods. My duty time is so-and-so. But near 12 o'clock, I used to go to take lunch at my house. I know the accused so-and-so because he was also doing the work of watchman. Today also he is present before the court. He was residing in the distance of 4 to 5 rooms from my room. On 39, accused went away to take lunch after about 12 o'clock. Thereafter, at about 12 noon, I also proceeded to take lunch towards my house. Then, please mark, I had seen the accused along with one small girl and one English dog who were standing on the road which was proceeding from the side of the jungle. At the time, accused was in watchman uniform. Then I went on towards my house to take the lunch. Now, the presence of the girl and this thing, just for factual, is not mentioned in the 164. It comes here. When I came back near about 12:50 p.m. and proceeded for my work, that time, please mark this, my lord, Lordship will ask me that question. I had seen that the said dog was tied on the window of Sanjay Rawat, PW 15, his brother, PW 14's brother. Then on 210, police called me in the police station. Then that time I came to know the dead body of that girl was found in one pond. Police showed me the photograph of that girl and therefore immediately identified her. That time I had stated before the police that I had seen that girl with the accused at about 12:10. Accordingly, police recorded my statement as per say. Now photograph of the victim girl shown to me. She is the same. Today accused present before court. He is the same. 161 shows the date as 3rd October, but with that, not cross-examination. It is true that where I was working, there was a master register maintained. Said register, we used to make entry when we used to go and when we used to come. Alleged pond where body of deceased girl was found a distance of 1 kilometer from my house. Near about 6 people are residing in my room. Somebody used to do the day duty and somebody used to do night duty. Near about 50 watchmen were residing in that area. On 110, I came to know that one girl was missing from that area. It is true, please see, my lord, that the police called about 30 watchmen in the police station for the purpose of inquiry on the ground of suspicion. Moreover, police also sent them for medical examination. I was also included in them. So the FSL 14th October, his sample also specifically mentioned. It is true, it is not true to say that on 210, police did not record my statement. Thereafter, the next day, the police also recorded my statement in the morning. There was a road of ingress, it's ingress, INGRESS and egress from the Unnati so-and-so. I have stated before the police that I have seen that dog tied on the window of Sanjay Rawat. I have never seen anybody. It is not, now that's all, that is all with the PW 14.
But where have you confronted him with his previous statement? You have not done that.
Now, 160, this is why I was defensive of 164 statement. I have not confronted him. I can only, it's there, it's not there, it's not there. I cannot.
So what does he say, by the way, just for our satisfaction, what does he say in that statement?
In his 164, it is there, Lordship, in his 164 statement, what he says is, when I went there, I saw the accused there.
Not the girl.
When I was going out from my lunch towards take lunch, I saw not the girl, not the dog, only me.
Where is that statement?
Yes.
Is it part of the record?
Yes, it's there. 396. It's exhibit 94, page 396. I'll just read the
Exhibited by the prosecution.
Yes, my lord.
Exhibited by the prosecution.
Yes, my lord. Yes, my lord.
Yes.
396. This is Pradeep Kumar. I won't read the full thing, my lord. Only that part which the lordship asked me. Please see the first paragraph only. I've been working as a watchman. I was appointed in so-and-so. At about 12 noon, Ram Kirat and his father left in my presence to have lunch. On that day, I too had left around 12:10 to have lunch. While I was going, I saw Ram Kirat standing on the road. Thereafter, at around left, that's all. At that time, I saw the dog title window of a room. So I've told them, because this is very crucial, I've told them, somebody who knows Marathi, they've cross-checked again, it is not there. So it is not a...
Marathi is just above this.
Yes, ma'am. So I've given it to somebody who knows Marathi so that it is not mentioned. Now, Lordship may kindly come now to PW 15. PW 15, I won't read the full thing. 264. 264, that is a brother of PW 14.
Does he say that in this that they learned that Ram Kirat attacked the said dog?
Yes. Yes. Now, PW 15 starts at page 264.
Yes.
The second paragraph I'll do. He's also a watchman. First paragraph, he's also a watchman. Second, on 39, when I went to my house and to take lunch, I had seen that one dog was tied to the window of my room. That's what he says. When I came after taking lunch, I had seen one person having long hair was inquiring with the accused, Kutta idhar aaya aur to bachi kidhar gaya. That time, accused was on lungi and banyan. Then I went away from the spot. On same day, I came to know one small girl was missing. Today also is present, is this thing. Now, cross-examination. Now, Lordship may kindly see para 4, the second sentence. Pradeep Rawat, that is PW 14, is my real brother. All people were knowing regarding the missing of that girl. Today, I do not remember whether I've given any document to the police, that's okay. On 210, please note, my lord, police called me in the police station. Police also called other 25 to 30 watchmen for inquiry on suspicious grounds. Police sent us for medical examination in the civil hospital. On the same day, police recorded my statement. It is not true to, I'm reposing falsely, so and so. No, police threatened me that they will implicate. It is not true to say that police threatened me that they will implicate me as accused in the present case. It is not true to say, say of the police have given false statement. Now, this person, Lordship may note that this person's sample is also included in the sample sent, everything, nail, hair, semen, everything is taken. Now, Lordship, since I've mentioned PW 17 also, 292, the so-called extrajudicial confession, 292, please see that, how he is declared hostile. Page 292. In the year,
How was the body recovered?
Yes, madam.
How was the body recovered?
Body, the police were searching for it. Then
at a distance of 1 kilometer it has come.
Around from the house, around 1 kilometer.
How did the police reach there? Any idea? Anyone who was deposed?
In investigation, somebody, it was a pond. The police, somebody must have informed the police. They reached there and they found. It's not, that's all. Nothing else come out of it.
Yeah, somebody must have said about this, that we were searching and we reached there. And
yes,
evidence
or something, or somebody said.
I'll just tell Lordship. Exactly, I don't want to make it. I'll just tell Lordship, sir. Just may I read by then? Lordship may see to. Dog squatters. I'll just read the relevant question to answer your Lordship.
Continue.
No, Lordship asked me, I'll just answer. I'll just read it, I'll come to that in a minute. Then on 2:10, when our police squad was taking the search of the girl, that girl, we had found dead body of one small girl in the muddy pond at about 2 p.m. Then we called fire brigade and removed the body. That's what it is. Search how they got the information. It's not. Now, Lordship may come to page 292, PW 17. Just check in the meanwhile, answers there. In the year 2013, I was working in the so-and-so. I was working as a rounder. Near about 22 people are working as watchmen in one shift. That is day shift, more or 20 working night shift. I used to check while taking the round. All these watchmen were residing at Manera camp in the Chawl, which were near Unnati Woods. Day timing was 8 to 8 and night duty was 8 p.m. to 8 a.m. During the lunch time between 12 to 2 for the period 45 to 50 minutes, they used to go at their house taking lunch by adjusting their duty. I know the accused Ram Kirat God. He joined duty prior to 6 to 7 days of the incident, but his father was working there since 2 to 3 years. On 39, one girl was missing. On that day, duty of accused was in phase 2 building so-and-so. Police came there for the purpose of inquiry and took some watchmen with them. On next day on 110 at about 8:20, I went for round. That time, the father of the accused was working on gate number 4, but accused was not present there. Therefore, I sent his father and called him on duty. When accused came there, I inquired with him why he has not come for duty. That time he replied that made tension may who. Then I sent him for duty. Then he also stated that मैं duty नहीं करूँगा, मैं आज के आज गाँव जाऊँगा. Police recorded my statement. I have narrated before the police regarding conversation between me and accused. Witness resides from his previous statement. Therefore, permission granted to learned APP for his cross-examination. Now, please see this move. Cross-examination by APP. I have stated before police that accused told me, आज duty नहीं करूँगा, tension में हूँ, मेरे से गलती हुआ है. That time I have stated to him that घर पे रहोगे तो tension कम नहीं होगा, तुम काम पे जाओ. Then he has replied to me that मुझसे बड़ा गलती हुआ है, मैं आज के आज गाँव जाऊँगा, इधर नहीं रहूँगा. Further, he also stated that कल पुलिस ने बुलाया था, उसी बारे में मेरी गलती हुई है. Further, I've tried to make inquiry in detail, but he has not stated anything. Intention mentioned in so-and-so, stated these facts before the police. Then I've also handled attendance register, so-and-so, so-and-so, so-and-so. Sorry.
Just wait.
Prosecution witnesses, my lord. This is the evidence against me.
Now, any evidence to the effect that where this construction of phase 2 building was going on? How far was it from the place of incident?
No.
Okay, very good.
Now, my lord, the evidence against me, what has been relied against me to sentence me, for convict me and sentence me to death is this PW 9, 14, 15 and 17. Now, what I just read to your lordship. Now, lordship, now I made some, initially I had made some material against me. Now lordship may kindly see the letter on 1410 by which samples were sent. That is page 373. This is samples of the 30 watchmen. Page 373. Date is 14/10/13 is when the sample is being sent. Lordship saw that on the right side. And please note there, I was arrested on 3/10/13. So the sample is being sent on 14/10. Now, please come to the next page, 374, serial number 9, facts in brief. That's right. Unknown accused with intention to commit rape. Then, lordship may come straight away to page 375. Serial number 21 is PW 14 sample. plain blood, so and so, hair, semen, nails collected by medical officer. 26 is PW 15. Now, what has happened to this? Prosecution has given us this letter, but the result of this FSL report, it's not. We don't know what has happened. We know that it's been sent.
Regarding the other watchmen.
Other watchmen. We only have this. Now,
why would the prosecution place that report on record unless it was relevant to the case?
Yes.
You could have asked them to summon it.
Yes.
You could have done that.
My only attempt
that
to show
doesn't take you anywhere.
Yes, my only attempt to show that those were sent.
Obviously, at the initial stage, all the people who were under suspicion,
yes,
they tried to collect scientific evidence.
Yes.
Nothing came around except for you as per them.
As per them, yes.
Yes.
Now, Lordship may kindly see the FSL report vis-a-vis me.
Yes.
Lordship may kindly see the page number. 424. Please come to 424. That is Exhibit 104. Now here, Lordship, see what all was sent initially. Serial number 6. Description of articles contained in the parcel. Full shirt wrapped in paper. Full pant, banyan, lungi, a pair of shoes wrapped in paper. Earth put in a polythene bag. Now, please see result of analysis, next page. Exhibit 4, that is the lungi wrapped in paper, is stained with blood at places. No blood is detected on 1, 2, 3, 5 and 6. That is the other articles. No semen detected on 1, 2, 3, 4, 5 and 6. Analytical noting report regarding DNA analysis will follow. Report regarding earth will follow. Now I'll show those.
Just a minute.
Yes, ma'am.
The prosecution doesn't even care to send any of the articles of the girl for comparison. This report only refers to the articles of the accused or the plain earth.
These 6 are the accused. Girls are sent separately. That is Exhibit 99.
Separately, why is that they are to be sent together for comparison? Yes. Anyhow.
Now I'll just tell your Lordship the result. Now see result, they say that DNA analysis and earth comparison will follow. Now DNA analysis, Lordship may kindly come to page 414. Exhibit 99. Now I won't read everything. See, Lordship may kindly see. This is no, I don't want the DNA analysis. But yeah. This is regarding the all the articles, serial number 6 of the girl that was sent. And to answer your Lordship's query, please see serial number in item number 6, serial number 78. Blood in a test tube label accused, blood in a test label nails. They put that. Please see the result. Then
so they never even contemplated sending the clothes of the accused for examination. Even if there was a lungi, there was some blood.
Yes.
They never were even under the contemplation that it might be the victim's blood.
Yes. Now, please see the result. No male DNA is detected on so-and-so, so-and-so, so-and-so nail clipping of right and left hand. Then the next sentence, Exhibit 7, blood. Those are the controlled samples of Ramkirat Murilal Gao, that is me. No amplifiable DNA is obtained from Exhibit 14, long hair, and Exhibit 15, short hair. Control profile of Ramkirat.
Lungi was sent.
Yes, is that I'll show after this. No amplifiable DNA is obtained from blood detected on Exhibit 4 lungi. So in that earlier report, Lordship says lungi will follow. This is that report for the lungi. Now this is nothing. This report I'm reading to show that implicate that. Yes. Now the earth, the shoe, port 26. That is Exhibit 105. Now, please see what has been sent. Serial number 6 at page 426, my lord. Bottom pair of shoes wrapped in paper, labeled so-and-so. Earth put in polythene bag wrapped in paper, labeled so-and-so. Result of analysis. Earth collected from Exhibit 5, that is from my shoe, tallies with earth in Exhibit 6, that is earth put in polythene bag, in respect of hue, physico-chemical characteristics and spectrochemical composition. Now, The mud in the shoe, like I said initially, matches the mud they took from the pond. Now, tallies. Now, with utmost respect, my submission is this. Now, that has to be by way of an elimination. You have to take mud from there, mud from there. It matches only this. If suppose this mud is there in the locality, this cannot be the basis to implicate me. And in addition to all other, this is my submission on this report. In addition to all my other submissions, 30th September is the alleged incident, 8th October is the recovery. They knew on 30th itself that this locality is there. They arrested me on 3rd, 8 days after the incident, 5 days after my arrest. They go, and if the prosecution story is to be believed, with utmost respect, what they want the courts to believe is, after the incident, 8 days, I kept my shoe intact without even cleaning it. Just like that, I kept it there, and then they came and
you didn't have the opportunity of 8 days. You were arrested on 2nd.
3rd, my lord. Incident is 30th. That's what I'm saying.
So
30th.
3 days you had.
Yes.
But were you a part of those people who were rounded up? You were not there amongst those.
I was not there. I was not part of those rounded up. And
what is the reason? 30th. First go round. First and second. They were rounded up on 2nd.
Second.
So have you put any question to the IO? Where was he when this rounding up operation was going on?
PW 18 lordship may say not. Just show me. PW 18. From 30th October to 2nd October is PW 16. It's yes, my lord.
Every query you are looking at your associates for answers.
My lord, page numbers. You know, it's page number is.
You need to learn from senior person, sir.
No, that is aspirational. That's yes, my lord. Lordship may come to PW 16 at 266. This is the IO. This PW 16 is the IO from 30th September to 2nd October.
Okay, let's see.
Yes.
Page is
266. Yes, he is not to answer. He has not said anything on what you're but I'm just reading it as after the Mundri PW 18.
30th September to
2nd October. Incident is 30th September. PW 12 registered the FIR. PW 16 from 30th September to 2nd October. In the month of October, I was attached to so-and-so police station. I made wireless message. Please see on 110, at the middle of the page, in between 7:30 to 8:45, I prepared the spot panchnama that I read to your lordships earlier, my lord.
Search.
Yeah, they call it search. I read the search panchnama. Complainant has shown the incident spot. He has shown those spot where he has seen lastly to his girl. Firstly, he has shown his own house where he was residing, stated that. Then he basically in this, my lord, he describes the search panchnama throughout. Then that's all. Now, lordship may see the. I won't read the chief examination, my lord, because in this, now to answer Justice Karol's query, my lord.
Just a minute.
Yes, ma'am.
This says one Prem Shankar Gupta had seen the victim girl.
Yes.
Who is this Prem Shankar?
He was even the search I mentioned not examined.
Not
in the search panchnama also is mentioned these people who were not examined. Now, lordship may come to page 268. Para 2, page 268. We called the dog squad to take the search. We have taken efforts, but the said girl was not traced out. Accordingly, submitted the report, now shown to me. Now, para 3. On 210, when our police squad was taking the search of that girl, we had found dead body of one small girl in the muddy pond near about 2 p.m. Then we called the person from fire brigade and removed the panchnama, etc. Then, my lord. Lordship may come to the cross-examination. Now, to answer your lordship's query as to where were you on 210, etc., all he says is, lordship may come to page 271, para 6. Sorry, we'll start with 6. Para 6, the last 2 lines. Yeah, sorry, para 6, I'll read, my lord. LH pond is an open space. Lordship got that, my lord? 271.
Yes.
LH pond is on the open space. It is accessible for anybody.
Mr. Basant, read the para number 2 on page 268, there's one very important
I'll read that.
fact stated by the witness.
Then we call the dog squad to take the.
Then I have recorded the statements of those witnesses who had lastly seen that girl.
Yes, my lord.
So up to 2nd, he says that by 2nd October, there is the last date till which he was continuing the investigation.
Yes, my
He had already inquired from the witnesses who had lastly seen that girl.
Yes, my lord.
So till that, there is no disclosure regarding the accused.
No, my lord.
You need to focus on that.
Yes. Then I've recorded the statement. No, what my submission is that PW 18, the next IO says prior to 3/10/13,
there is no one.
Nobody has said about the accused. That I'll come to that in a minute. That is what. My lordship may come back to para 6. This is the I have recorded the statement of the grandmother of deceased girl so and so. She also stated that she can search, but she has not expressed her doubt up towards any watchman. I have not recorded a statement of any witness on 110 stating that anybody had seen the girl so and so, so and so. Now, para 7, your lordship may kindly see to answer your lordship's query. He says it is not true to say that suspicious accused brought in the police station on 2nd October. The suspicious accused was not brought in the police station before me. It is not true to say that I am deposing false regarding the identification of the accused. It is not true to say that on today I am deposing false against the accused. That's all he says when we put that question to it. Now please come to the, now I can't, 302 Miller. Page 302.
Main IU.
Main IU Miller. On 310, second paragraph, I have recorded the statements of 4 witnesses. Those are lordship may note, PW9, PW14, PW15, and one person called Mohammed Kudus. He is not being cited as a witness. Again, I visited on the incident spot and I found that in the watchman chawl in room number 2, some blood stains on the earth and hairs. Now, room number 2, lordship may note, according to the prosecutor, is where the actual incident occurred. Room number 4 is where I stay. Therefore, I seized it. Accordingly, I prepared Panchnama with Exhibit 34 in the presence of 2 witnesses. Now shown to me, it bears my signature and signatures of 2 witnesses. I have also seized 1 shirt and burden from the spot and the pieces of cement koba having blood stains and 1 piece of cement koba without blood stains. For removing the, lordship may note, I'll read the FSL report. It says even the one they sent saying blood stains, it says no blood, no blood.
Even this is not the instruction.
Not at yes, not at my.
Not from the room of the accused.
This is a seizure. This is not
simply a seizure.
Yes. I sealed, said so and so. Now, my lord, now please see, now the next page, that is 303. Accordingly, I prepared the Muddamal receipt, now shown to me, it bears my signature, contents are true, it is marked as so and so. On the basis of statement and investigation on 3/10/13, I have arrested the accused so and so and also filled up his arrest form. It is now shown to me, it bears photo, thumb impression and signature. My signature and signatures contents are true. It is marked as Exhibit P1, 81. Regarding arrest of accused, I provided information to the owner in writing, so and so. Then, now this on 4/10, I forwarded the accused for his medical examination by asking specific questions whether he is competent to perform sexual act. When I have collected the medical certificate, it mentioned as aberration on his private parts. For his medical examination, I issued letter Exhibit 52. It bears my signature. Contents are true. On 7/10, necessary samples of accused and deceased were collected and forwarded to FSL at Kalina for DNA other examination. Forwarded those articles which are seized. Now, 2 letters 7/10 shown to me. They are correct. They are marked as so and so. Now, regarding this injury, I must tell your lordship, PW10 is, I'll just tell you lordship how this examination happened. PW10 is the doctor after the incident, after the arrest, I was taken for medical examination. PW10 conducted the potency test and issued a certificate saying that I am capable of performing sexual act. Then he says in his evidence that to examine injuries on private part, he referred me to a doctor called Dr. Rokde, who's not been examined. Now, that doctor who examined me and noted the injury is not examined. What happens is, in this medical certificate saying a potency sexual act, that doctor's opinion is written by hand, different handwriting. And Rokde notices that these injuries and says, etc. And that doctor is not examined. These injuries are also approved through PW10, who's actually signed only for the potency test. So that is the, I'm just saying, even the injury. If your lordship wants to see, I can show that page 222 is the document which I'm referring to now. It starts at 221. It's not a very clear copy, my lordship will bear with me. 221. It's handwritten, lordship may see. This is so hospital, history of sexual assault, requesting for sample collection, etc. Next page. Then before that, so and so, there is opinion, that is this PW10's opinion. There is nothing to suggest that he is not, whatever, found in him, which is suggestive that he is not capable of sexual act. That is, saw that, my lord? That is PW10's. Then surgeon. That is the injuries are mentioned by the surgeon.
Nothing abnormal
lordship
found in him, which is suggestive of he is not capable for sexual act.
Suggestive that that he is not capable. There's nothing. There's nothing found in him which is suggestive of not capable. So he's capable of. So that is PW10. Then lordship say below that surgeon. Now that is a different doctor, Dr. Rokade. This is case of the prosecution. That's what I'm saying. Now this injuries to my private part, abrasion on foreskin, etc. on the private part, that is mentioned in different handwriting by the surgeon. But it is mentioned, it is signed in this report also, who signs of the medical officer who's PW10. So this injury is noted by Dr. Rokade. Dr. Rokade is not examined to prove that injuries. It is PW10 who mentions about those injuries.
Is there any corresponding injury on the body part of the victim?
Yes, body. Yes, body part.
Yes.
But one thing, tell us one thing. What is the evidence on record? That the crime took place in this room.
Yes, madam.
1. 2, that the body was lifted and because it has come, the pond is at a distance, is at a distant place. Correct. It's not close by.
Yes.
What is the evidence there on records to show your last scene is that you were seen with the girl?
Yes.
Assuming hypothetically that that it inspires confidence. What is there to show? We'll ask the prosecution, of course, that the body was, the crime took place in that room.
Yes.
2, someone bodily lifted that child and dumped it into that.
And then no one saw. The thing is that room 2, that's about a kilometer away. It's a broad daylight, 12 o'clock.
To answer lordship's query, it's actually only in one word. There's nothing on record. There's nothing on record. The room number 2, where the injury occurred, they seize these articles, not recovery. They seize these articles. Other than that, there is nothing. And to say how the dead, if suppose the incident occurred in room number 2, how it reached, it's not. Which is why I read fully PW 9, 14, 15, 17. This is the evidence against me. What your lordship sought, what I just read, is the only evidence against me.
Yes. Lordships, to answer my Lord Justice Karol's question, para 23 to 26 on the injury found on the foreskin of the accused and how it has been correlated to the injury.
You need not labor on that.
Right.
I was corrected by my lords that there is corresponding.
There is correspondence, and they have analyzed his 313 explanation also, as well as the testimony of the doctor who has examined him.
Need not labor on.
So that, yes, and they've discussed the medical jurisprudence on it also.
Ms. Bobde, we
Yes.
have already reappreciated
Yes,
this.
yes, yes.
You come out with the best evidence you have to correct it.
Yes, so lordships have already seen the testimony of the 3 witnesses who have claimed to have seen him. One of them has expressly stated to have seen the accused with the girl. Apart from that,
both these witnesses do not make any disclosure till 30th September that they had seen the girl and the boy together. Only one of them says so.
Yes.
Now your case is very specific to the fact that the incident took place on 30th September around 12 o'clock.
yes, around in the afternoon.
Come to page 292.
292.
Yes.
That
He
is
is the supervisor.
extra- Yes.
Supervisor, right?
Yes.
Now come to his para 1 and last, para 2
Para 2.
and last 2 lines.
Last 2 lines. Then he has also stated that
Last 3 lines.
last 3 lines.
On that day.
On that day. Is at page 292.
Page 292.
Yes. Examination
Last
in chief.
3 lines. On that day, duty of accused was in phase 2, building number 5, and he was on
day duty. He is your witness.
Yes.
He establishes presence of the accused in the under construction project.
Lordship, but it's lunchtime.
No one
So
says
they-
that he has come from there to this place. In lunchtime, he comes there, take this opportunity, a small window.
Yes.
Who says so?
Lordship, sir, just
You see,
above
you
that,
are
we
very
see that-
emphatic on the aspect that next day he did not come, and so I went and approached him.
Yes. Lordship, but during the entire day, he has said above that that is the lunch timing, and that is why all the other chowkidars are also found to be having lunch. One of the 3 witnesses says that I was also having lunch with my door open.
Okay.
So that is the
Alright, so
prosecution version.
assuming that
Yes.
he went for lunch on that
Yes.
day, then next day he did not come because he was under tension.
Stressed. Yes.
But after this incident, he comes back and reports for duty. Because the supervisor doesn't say that he did not come back after lunch. Is it a normal conduct?
Lordship, that would be because he also said that काम पे नहीं आने से कुछ नहीं होगा. I mean, he says that
To what you, adding to what my lord has said.
Yes.
Supervisor's statement is recorded on 12th.
12th.
Yes.
For so-called extrajudicial confession, if he had made on 3rd, then the supervisor was very much aware of these incidents. The close quarters, these incidents are happening. What about the conduct of your witnesses? One of the witnesses is a signatory to that memo of search proceedings on 1st, Pradeep. That's
Yes.
right.
Yes, Your Lordship.
And he
Pradeep Kaur.
doesn't, if he had seen the girl somewhere, he would have spoken out immediately that I had seen the girl with the dog at such and such time. So what is his conduct regarding that? And so far as the second witness of last scene,
396.
who in his deposition says that I also saw the accused, you have proved his 164 statement. And in that 164 statement, there is no such fact that the accused and the girl were seen together. It was only the accused. How is it last seen then?
Yes, Your Lordship.
Treading on very thin ice. Hardly anything. For such flimsy testimony, the man has been behind for 20, almost 13 years. Well,
And facing death. Lordship, may I just also read the medical testimony, although Your Lordships have already seen as far as the.
There's no dispute.
Yes.
So,
But there's
so
no
when the
correlation.
girl was assaulted, she was murdered, there's no dispute.
Lordship, I just want to point
And then
out
one more thing.
the DNA is not
As my
traceable.
lord just asked you,
Yes.
the girl you say was killed in room number 2. Incident takes place in the afternoon. It's a chawl, a very congested area. The accused lifts the body, manages to dispose it of 1 kilometer away.
Carried to the pond.
Can it be even accepted for a moment? Seems that the incident took place at some other time. That's what the likelihood is.
Amount of blood found is also.
It's
They have not been able to even
Thing.
get the blood group from it.
All right, Likhe. Third counsel for the party. Please allowed. Your judgment, conviction, sentence set aside. Appellant was in custody. At least forthwith. If not wanted in any other place. You'll get the order in a week's time.
Obliged. A very patient hearing, deeply obliged.
Great.
Mr. Vasan, thank your colleagues.
Absolutely, my lord. I thought it was.
Log of 39.
Yes, my lord.
Project 39.
Now they are called Square Clinic. They have moved to Nalsar now. Square Circle, sorry, Square Circle.
Square Circle.
Yeah, so but
Square
same,
Circle.
same people, same people. That's unbelievable what they do. It's really unbelievable.
And we'll tell you,
Yes, madam.
frankly,
Yes, madam.
in all these cases we have heard, we have not even in a single case referred to those so-called reports.
Yes. She sat with me yesterday for a long time. They said only if they ask you read it, otherwise you keep so they what they do is unbelievable.
Yes, no doubt.
Obliged.
But then these reports are coming out after 10 years of the incident.
Yes.
So what was the mindset at that time? That would be the relevant consideration.
तेरे घंटे हो जाएगी. So somebody making a mention in the morning about some urgency.
Next matter is only for fixing date.
For early date.
Your Lordship may fix it in August.
Huh?
29.
Early hearing ki na? Your application
Only early.
Item number?
29.
Your Honor,
Lordship may fix it in August, first week.
Some date in August?
Yes, sir.
Partition suit 2000. Leave was granted in 2009.
All right. 7th August.
Your Honor, there is item number 17.
17.
Only 17. 17.
17 is 17?
Yes, I'm sorry.
Yes.
17. It is very urgent because they have filed an execution application before the National Commission without disclosing that statutory bail is pending here. They have recently filed it, so that is important.
Next week,
It's already listed for 16th, they will execute it, my lord.
what will happen if they?
My lord, they filed just recently, my lord.
They filed an execution.
Execution now, statutory appeal is pending. It has not achieved finality. They have not disclosed it. They have just misled the NCI.
You have a stay order?
No, stay order not there because stay order was earlier there. They were tagged with earlier applications, earlier petitions. That was a decided on preliminary issue. So this was detagged. And now they have filed because they have mentioned that they have changed the counsel. That is, they are filing it without disclosing that statutory appeal is pending. It has not achieved finality. 14. My lord.
My lords, I seek to mention item 6. My lords, we moved a mentioning application and then the matter has been listed. My lords, it's an FIR quashing. The trial has not been stayed, my lords. I am a 70-year-old lady and the second accused is my daughter who's 50-year-old. Against.
Lordship of appearance.
My lords, may I have it this side of the vacation, my lord.
For respond number 2, I'm seeking
Item number 36, Lordship. Item number 36, urgent status quo is required.
My lords, they have multiple opportunities have been given.
Lordship, in item number 36, urgent status quo is required, Lordship.
Counsel for the respondent state of?
Respond number 2, your lordship.
Respondent number 2.
The complainant, the state has filed.
This one granted. 1 week and no more time to file counter affidavit. Let's again on 14.
Let's item.
Grateful.
Item number 17. My lord has asked for 14th. Can it be possible for 15th?
No, 15th is Thursday. All right, 15th.
Well, item 19 was also listed after mentioning if my lords may place it next week.
You inform the court martial will come next week.
Next week.
Lordship, in item number 36.
Not paying, in fact, reiterating the contempt also. Husband is not paying the amount which is required, Lordship. I mentioned Lordship kept it item number 3. Unfortunately, my lord.
It will retain its position in the next week.
My lord, higher up on the board, that's only requested.
That's what he has said.
Please, my lord. Please, my lord.
Yes,
Lordship, in item number 36. Lordship, in item number 36, urgent stay or status quo is required, Lordship, because the matter is pending since last 2011, Lordship, and petitioner and respondent number 1 colludely sell the property to another person and they have not paid the full consideration, Lordship.
All right.
So at least status quo is required, Lordship. They are the original. We are. I'm the.
Matter.
Yes, Lordship.
My lords, item 38, my lords.
Yes.
Item 38, my lords.
That election matter?
Yes, my
Club
lord.
matter, huh?
Yes.
I'm looking for you only.
That's okay.
Everyone has taken a right.
No.
You. What day do you want?
My lords, Friday, my lord. No, nothing. What has happened is there's an order of this court, my lords. The previous election happened. There's an order of this court. So Friday, my lords, short matter, IA is there, my lord.
Friday only. This Friday, no, not possible.
The elections are slated for the 18th, my lords.
No problem. We'll have it on 14th or 15th, whenever you want.
14th, my lords.
My lords, item 47, my lords. Last, it was listed on 27 January. Then your lordship granted, directed to list it after 2 weeks, but it was not listed. Then I mentioned on Monday, then it was listed today. Again, this matter will not reach.
Yeah.
So if your lordship may list it on Friday or next week, your lordship.
Next week, huh? 15th, 14th, whatever you want.
14th, your lordship.
14th.
Much up.
Lordship's permission, may I mention item 5, Manoj? That
Yes.
CBI and with power of investigation in another state without consent. That matter, Manoj. So, Manoj, the Lordships had kept it for today. Because next week, if it can come up sometime, Manoj. The appropriate date.
14th? Everything will come on 14th.
My lords, then can I request for 13th, my lords? My lords, 13th for 38, my lords.
Very good.
Obliged. Great.
on behalf of the your lordships have directed them to make calculation. They have filed an affidavit. So formally they have not complied with, but I will show my lord what was actually intended, what actually transpired. They have just avoided, skirted that altogether. But for that, please have a look at page 96 of my petition.
Also, I'm appearing on behalf of the respondent. Arguing counsel is busy in court number 8 in part head matter.
Caller.
He is arguing.
Is she on her legs?
Yes, it's.
Just go and check up. No problem. Yes.
Please have a look at page 96. My lord, petitioner is H.K. Patti.
Yes.
And right hand side column is Vrindavan Das. And my lord, your lordships, my lord, way back in 95 had said that they are to be treated on par. My lord, 96, my lord, Vrindavan Das was given, my lord, the circle UDC, which I was entitled to at the same time. And then he was promoted, various posts which are given, my lord, promoted to the post of head assistant, then promoted to the accountant superintendent, etc., etc., worked as accounts officer. And my lord, I just remained on the office superintendent till my retirement because my petition was, my lord, heard and disposed of at the time when I retired. But in that background, in the earlier round, what was directed by your lordships, that your lordships may see, page 72. 71. When my lord, I was denied that post of office superintendent, but I filed petition, etc., etc., and then that was
which have been given to respondent number 1, when the virtue of holding the post of so we do not find any basis of treating respondent number 1 differently from when the
yes. So I am to be treated on the same lines. Therefore, my petition was filed in High Court. See my prayers at page 103.
Yes.
Therefore, prayed that issue rule nisi, calling upon the respondent parties to show cause as to why petitioner shall not be given promotional and financial benefits, including pensionary benefits, for the post of account superintendent, assistant secretary, accounts officer, etc. And this is what was intended when your lordship directed them to make calculations. Since he is 95 years of age, if he is to be given the benefits on par, what will be the, and your lordship in fact put to them, if it is somewhere around 1 crore, we will just stop at that. And yes, Lord, please see the order that was passed by your lordships. Although, Lord, it doesn't explicitly say that calculate all those promotional posts to be held by, on assumption that he has held them, what will be the difference? Lord, order dated 2nd April 2025. Prima facie, we are of the considered view that the order dated 8/9/2020 passed by the respondent number 1 Paradeep is in the teeth of judgment dated 8 November 93 in the original jurisdiction case number so and so, as affirmed by this court in SLP, which I showed at page 71, titled so and so. Let the respondents place on record the calculations of the monetary benefits to which the petitioner would be entitled, considering that he is placed at par with Vrindavan Das. So we will all promotional avenues to be actually we will assume to be on that basis. What they do in the affidavit is, please have a look at the affidavit which is filed.
3rd of May. 3rd May.
Yes, my lord. No, it was the hearing. Lord, please see para 4 first of this affidavit. That it is respectfully submitted that the date of joining of Shri Vrindavan Das was 16/8/56, which is not correct. He joined in the state government in 56. I joined in 48. whereas petitioner was absorbed in the port service with effect from 3464, which clarifies that from the date so and so, he was senior to petitioner. My lord, your lordship had shown to them last time at page 62 in the earlier judgment of the High Court that they tried to raise this contention that Vrindavan Das was senior, but that was not accepted. Please have a look at page 62, my lord, which was shown by your lordships only to the respondents. Para 3. Opposite party number 1 has filed its counter affidavit contending inter alia that earlier decision of this court in the case of Vrindavan Das is not applicable. It has been further stated that the promotion to the post of OS was given to the then senior clerk who was senior to the petitioner on the basis of. So, my lord, this was argued by them, not accepted by the court, and directed that I should be given all benefits on par. Although, my lord, monetary benefits for OS were given, substantial promotions, etc., were not, my lord, taken into account. Therefore, I had to file a substantive petition, which I showed.
Yes, gentlemen.
And, my lord, they please see the calculations given by them.
Sought accommodation with arguing in court number 8. It's a part-heard matter.
Oh, who's the person?
Deepak Kumar Jana.
On his legs?
Yes, on its leg, court number 8.
We'll pass over, just call.
Yes.
In any case, tell her that, tell him that we will not be hesitant in calling you chairman of the port trust to be here. Just pass it. Just pass it.
Please.
Issue is settled, Arjuna.
Through to my request for passing while our trend begins.
There's special bench now. Pass over, you will have started. What is this?
My lord, this relates to the investigation of mining leases by the Karnataka State Forest Department and the issue of whether the magistrate's approval under 155 CRPC is mandatory or not. The High Court quashed the investigation only on the basis that the permission under 155(2) of CRPC was not taken adequately. Whereas in this case, what had happened was the magistrate had written permitted on the file. They found that to be inadequate, quashed the matter. We are here in appeal against that judgment, my lords. My lords, the history of this case essentially goes back to the year 2009, when the Honorable Supreme Court established the Central Empowered Committee, my lord, to look into illegal mining leases across the country, and especially in the state of Karnataka. May I begin with the facts, my lord, or move straight?
Who's to argue?
Well, it's Mr. Shoaib Alam is leading me, my lords. I'm just requesting for a passover.
Okay.
Right.
Yes, next.
303 minutes, may I please? This is the lower court. The trial court, in fact, minutes, convicts him, goes in appeal minutes, conviction is upheld, goes in revision minutes, where the conviction is set aside minutes. So minutes, I am here minutes against that particular order minutes, and minutes, the order of conviction minutes has been set aside by a 3-page order minutes. Kindly have a look minutes. Well, the charges are this minutes, that the police got information that certain members of some Naxalite people are hiding at a certain place minutes. During the raid minutes, it is one person is apprehended. That person points a finger at this accused here, saying arms are lying at his place. During the raid, those arms minutes are found.
Lordship's order, I'm appearing for legal aid in this matter. I see where your lordships are heading towards. Just one submission will be there. I have gone through the order. Yes, there is some. However, lordship, by reading the impugned judgment, there is even more problem in that. The reason is
The informant himself is the investigating officer in this matter. And Lordship, this issue has been dealt by this court in catena of judgments, whereby this court has prohibited and lost it. Lordship, it's a Madan Lal state of Punjab.
What does it deal with?
Lordship, that was NDPS. I know that. Lordship, however, state of Bihar, PP Sharma, Megha Singh, state of Haryana, all these were TADA matters and arms matter. So Arms Act was there in those matters. So I knew, Lordship, this question will come. That one was NDPS and other was of Arms Act and TADA.
We are asking you to tell us whether we should decide it on merits or we should remand it. You tell us that. That's the only thing we can.
Lordship, since
we'll decide it on merits or defects.
Lordship may remand back the matter. That will be.
It's a concurrent conviction. Why can't we do it?
Then Lordship may. Then what I would request
There's a concurrent finding
because there is no FIR and other things in the matter. Just there is impugned judgment. That is all what I have got to assist your Lordship. Nothing is there other than this. So I am also having.
We call for the record of the trial, the courts below.
Fine. Months.
Let records of the courts below be immediately called for by the registry. Registrar Judicial shall ensure that the record is summoned to a special messenger. List on इसी side कर देते हैं. List on this side of the way date. अभी बता देंगे जो date हो. Now, the paper book in the digital form be supplied to the learned counsel before the next day.
So very grateful. So grateful, Lordship.
Yes, please.
Lordships on the last occasion had asked me to assist the court. So I have filed a short note, minutes. It should be like this. The note is short, only that I have added some judgments. Lordships have. Lordships, the only question which arose was whether the state can conduct narco-analysis the accused without the consent of the accused. So that issue, my lord, stands settled by your lordships. Went in service. In my note, I have extracted the questions. If your lordships have page 1, the questions at para 3. Lordships have. This is Varale has the. Yes, sorry. Yes, the questions which have been extracted at para 3. Whether the involuntary, plus what happens in narco is also extracted. The questions which arose in Selvi's case are extracted at para 3 of the note.
Yes.
Then middle lordship will have para 4. I'll just read what narco-analysis means. Narco-analysis involves the intravenous administration of a drug that causes the subject to enter into a hypnotic trance and become less inhibited. The drug-induced hypnotic stage is useful for investigators since it makes the subject more likely to divulge information. The drug used for this test is sodium patanol, higher quantities of which are routinely used for inducing general anesthesia in surgical procedures. Now, after this, your lordships have held in paragraph 146 of the judgment. This honorable court has come to the conclusion that narco-analysis technique involves testimonial act which would infringe Article 20 within 3 of the Constitution. Plus, I have extracted para 146. I'll just skip it for the time being. Then, at page 3, para 6 of my note, I have mentioned that in para 226 at page 370, It was held that subjecting a person to the impugned techniques in an involuntary manner violated prescribed boundaries of privacy, which infringes Article 21 of the Constitution. Then, Milos, at page 239, para 374, please permit me to read this. However, it is quite conceivable that administration of any of these techniques could involve the infliction of mental pain or suffering, and the contents of their results could expose the subject to physical abuse. When a person undergoes a narco-analysis test, he or she is in a half-conscious state and subsequently does not remember the revelations made in drug-induced state. In the case of polygraph examination and so, the test subject remains fully conscious during the test, but does not immediately know the nature and implication of the result derived from the same. However, when he or she learns about the contents of the revelations, they may prove to be incriminatory or be in the nature of testimony that can be used to prosecute other individuals. We have also highlighted the likelihood of a person making incriminatory statements when she is subsequently confronted with test results. The realization of such consequences can indeed cause mental pain or suffering for the person who was subjected to these tests. The test results could also support the theories or suspicions of investigators in a particular case. These results could very well confirm suspicions about a person's involvement in a criminal act. For a person in custody, such confirmations could lead to specifically targeted behavior such as physical abuse. In this regard, we have repeatedly expressed our concern with situations where the test results could trigger undesirable behavior. Because other paragraphs have also of the judgment which are relevant, I have extracted, which are, because I'll not read it today, time is short. Now, what we have done after that, Milos, we have taken some of the High Court judgments which have followed Selvi from pages 6 onwards, and we have summarized those High Court judgments and also annexed copies of those judgments with those notes, Milos, which says that, that you can't in any manner tell the accused that he has to go the test. Now, two more propositions which has come up, which may also need some clarification. Can the accused volunteer for it? So one Rajasthan High Court judgment says that if the accused wants narco-analysis test, the court can order such a test. I think, Milos, that's not the correct proposition, because it's for the investigator to decide. If the investigator says, I need narco-analysis test, the accused can give consent or not give consent. But the accused can't go to court and says, please conduct a narco-analysis test on me. Number one. Number two, if such a test is conducted, what is the legal veracity of such a test, Milos? When it's produced in evidence, Milos, this is only a kind of a imagination that he is running through. So if the test is conducted and the test results reveal something, it can only be the tool to investigate. It can't be that that report is now used for or against the accused. Suppose the test report is entirely exculpatory. Well, I don't think so. The court can relax. Okay.
That may be only one test.
Therefore, it can be only as an investigating tool. Sorry.
Mr. Agarwal,
Milos.
on the second proposition,
Yes, Milos.
the three issues which are
Possibilities. Yes.
One is
Yes, Milos.
whether you can force the person,
Yes, Milos.
subject him to narco-analysis test.
Yes.
That question
Is settled.
Settled by Selvi.
Yes, Milos.
And now subsequently followed by various sides.
Yes, Milos.
Now, Selvi must be by three judges.
Three honorable judges.
Three judges.
Yes, Milos.
So the second issue arises, which arises for consideration, is whether he can volunteer.
Yes, Milos. No, he can ask for it. The prosecution doesn't want.
He can ask for it.
Yes.
Why should he not, or should the investigator not take that as part of the investigation
Yes.
or not?
Yes,
that,
Milos.
that is one more.
Correct,
That is the second issue.
Yes, Milos.
The third issue is whether that alone itself
Yes, Milos.
can be used as a material against the accused to convict him.
Or for the accused, because accused says, I have not done anything, do narco on me. Yes.
To convict him.
Or acquit him, Milos.
See,
Yes.
it will be used only
To convict.
alone.
Yes, alone. Yes, Lordships are right.
Alone to
Convict him. Lordships are right.
On the third proposition also, we see no difficulty. Obviously, there has to be some other material.
Yes, Milos.
Perhaps. But on the second question,
Yes, Milos.
why is it that the investigators' choice is left? Why should the investigator not take this as a part of an evidence
Yes.
during the course of investigation? Because after all, the accused is also entitled to lead as defense evidence, no? Cannot not be used in that sense.
Yes, lordships are.
Because he has a right, and the investigator has to, what is that the investigator is required to do? Unearth the truth during the investigation.
Right, my lords.
And this is also part of the investigation. Why should he not do it? Is what we are just done.
So it is not a part of the investigation, it is his defense, my lords.
No, correct.
Yes.
But some suppose,
Yes.
after all, to find out whether he's guilty or not.
Right.
This is also one of the processes of investigation.
Correct, my lords.
Confessional statement, for example.
Yes.
To what extent it can be used?
Used, yes.
You cannot say that in India, confessional statement cannot be.
No, it can be
accounted for.
Section 30 is clear.
Very, very clear.
Yes, my lords.
So that is also part of that process.
But there is one Rajasthan High Court judgment which I have also annexed, where he went to the High Court saying, please direct the investigation to take narco on me, because I want to go through the narco process, and the High Court directed. So whether that is what your lordships contemplated in Selvi, or is it only the investigating tool as an investigating mechanism, and he can say, no, I don't want to.
Till and so long he says that, look, Article 20, I'm protected.
Yes.
Then there is no difficulty.
Then perhaps yes, but it's suppose
he will volunteer.
He volunteers. Lordships are right. I mean, we can't. Yes, fellows.
I think on all these three, what do you say?
And the last point was also that if he has to, just 1 second, you want to say something? One more thing is, there's one good Bombay High Court judgment where he found, where if he has to undergo this test, then he must be fully informed of his right, and the manner in which it has to be done has also been laid down by Bombay.
All that, as senior brother said,
yes,
it will come when the investigating officer seeks his test.
Yes.
All that to make him aware
yes.
that he has a right to say no,
yes.
protecting that, his
yes.
privacy, all that will come when the investigating officer needs his narco-analysis test.
Yes, so here he has...
We were on the other aspect of the matter,
yes.
where the accused volunteers for.
Yes.
Then why it should not be one of the part of process of the investigation to unearth the truth, admissibility, otherwise subject to the further process.
Further material which can be. This can't be the only basis. Lordships are right. Lordships, that caveat can be there.
Correct.
May I add one thing, my lord?
Yes, sir.
My lord, after charge sheet has been filed, my lord, such step is going to be taken, my lord.
Sorry.
Charge sheet has been filed in this case, my lord.
Supplementary charge sheet can
But for that, my lord, there is no order under section 173(8), my lord, subsection 8, my lord, that further investigation should be started.
The supplementary charge. See, that is the, you are into the main merits of the matter. We are not into that. We are only into as to whether.
Question one, this question, whether.
In supplementary charge, you can always be there. What is wrong? What is there?
Well, just on that proposition, there's one Kerala High Court judgment against and Rajasthan which allows. So, lordships, I put both in my note. Kerala High Court at page 10, para 18 says that it should not ordinarily be allowed because the material has very little evidentiary value. In a Rajasthan High Court judgment, the High Court says this is a part of the defense of the accused under section 233 CRPC. He is entitled to, whether the court will rely upon it or not is a different issue. So, lordship may just note Kerala High Court is, Milos, that judgment I have annexed, Milos. At
we have seen it.
Yes, Milos. Yes, Milos. So, I put both judgments there. This is the only point where it is not clear. But if your lordships clarify that is ultimately for the court and him to decide whether he can use it on the investigating tool, then it's a matter.
What do you say?
Yes, Milos.
Do you wish to argue anything else? We filed your submissions?
We got I'm placing it on record, my lord.
What do you say?
Sure.
Sir.
My lords will kindly appreciate, my lord. Lord, in India, my lord, the narco-analysis tests are administered in the presence of experts in the field, my lord, like the psychiatrists, the clinical psychologists, the doctors, the supporting nursing staff, my lord, and the videographers. My lord, with the aid of the narco-analysis test, my lords will kindly appreciate, my lord, it will help in yielding the information which is a basis for further investigation. My lords will kindly appreciate in this case, my lord, the father of the petitioner, my lord, he had given a statement
that the lady was taken to Ayodhya, my lord, and he was thrown from the bridge in the river, Saryu. The body was not recovered, my lord. And only this is the basis we wanted to have the narco-analysis test.
And can you force? That's it.
No.
In view of survey, you cannot. No?
I bow down to my lord's, my lord. I am squarely covered. That is the law of the land, my lord. Selvi is the law of the land. But the thing is, my lord, the technologies have advanced, my lord. If my lords will kindly see, my lord, that in modern times, with the advent of technology and increasing knowledge of the same,
we have seen that. But
the accused and criminals are gaining a lot from it, my lord.
The honorable judges of the bench say that it is not permissible when two of us cannot say that. No, it is permissible. Yeah, we'll see.
Grateful to Lord.
Yeah, so very confident. You heard the Ganada Micros, there's also the nurse counts strategy. See.
Obliged.
You yesterday mentioned.
Yes, Your Lordship. He was actually before the code number 8. Yes, he informed us.
Have some other day.
No, we'll have it some other day, but with the chair, with your chairman being here.
No, I have to.
Yeah, we have gone through it.
Please, Lordship. You have paid your Lordship.
Let us be very clear.
Please,
we are
Lordship.
very clear.
Please, Lordship.
Today you go and argue a matter before another bench. We are quite convinced that the order has not been complied with in letter and spirit. More so in letter, if not spirit. So when will your chairman be here? You tell us that.
Your Lordship, kindly.
We are only telling you today. VIPs. You are not saying it.
No. Lordship, let me place three things here before Lordship, so that you can Lordship hear it.
You are free from that bench.
I cannot go now, Your Lordship. It is already 4. So court has to rise. Court has to rise now.
So you are not on your legs.
No, Mr. Go. I just come with this. Just.
No, we were told that you are on your legs. So
I was. Then I
no
have.
Problem. No difficulty.
Your Lordship, kindly.
Now you tell us now.
Your Lordship, kindly see the.
Kindly please come to page 71.
Page 71, Your Lordship. Please, Your Lordship.
Now, what is it that this court is there?
Your Lordship, kindly see the last middle of the para, the post of circle 871, Your Lordship.
Yes.
Middle of the page, the other post of circle UDC was held by Vrindavan Das. By impugned judgment, the Honorable High Court has given the same benefit to the respondent number 1 was given to the Vrindavan Das by the High Court judgment set 27th March 1972 in OJC number such and such. The shared benefit has been given to the respondent number 1, Vrindavan Das, by virtue of their holding the post of circle UDC. At the time of creation of the post of officer superintendent, we don't find any basis treating the separate differently from Vrindavan Das. No case therefore is made out interfere with the judgment of the Honorable High Court as regard to the apprehension of that the employees may claim similar benefit. They started in the High Court while dealing with the review petition has observed that the apprehension that means senior to respondent 1 might take claim in the benefit without any concern.
Okay, now
Your Lordship, 1993.
one by one. What was impugned here?
Your Lordship,
what was impugned here?
Impugned here is we are in appeal. 1993 order. 1993 order.
Which is that page?
That is page 107, Your Lordship. Not sorry. That is at page 57.
57 onwards.
Correct.
57.
Now, at page 57, kindly come to page 62.
66, Your Lordship, can go directly
to page 62 first.
62, Your Lordship. No, May I read para 3?
Yeah.
Your Lordship wants me to say para 3? I have it. The opposite party number 1 has filed its counter affidavit containing intelligence that earlier decision of this court in this case, Vrindavan Das is not applicable to the petitioner. It has further stated that the promotion of the post of officer was given to the then senior Kara was senior to the petitioner. On the basis of the recommendation by the Departmental Promotion Committee, petitioner being ineligible consider the promotion. no ground. Your Lordship, kindly see the last para, which was given the benefit, Your Lordship. Page 66, Your Lordship. Page 66, Your Lordship, para 6.
Have you heard learned counsel for Pulalin?
Your Lordship, kindly, no, Your Lordship, kindly, Your Lordship, kindly see the accounts. Your Lordship, kindly see the accounts, Your Lordship. Kindly see the accounts, sir. Your Lordship, kindly.
Intent of that.
Your Lordship, we have no, you have no, your kindly, Your Lordship.
Now, please, we are dictating.
Please, Your Lordship, kindly help him on it. You know, accounts which was given is considered with the Vrindavan Das, at par with the Vrindavan Das, Your Lordship. At par with the Vrindavan Das. No, I understand, but Your Lordship.
Court to dictate the order, please.
Your Lordship, kindly, one.
Would you allow the court to dictate?
I understand, but Your Lordship has to pass the order. But what I'm saying is, Your Lordship, can consider.
We are only calling your MD today. We are not sending him behind.
No. I'm not on that. What I'm saying, Your Lordship.
Thank you. We are concerned more so with the implementation of our order dated
Second April.
No. Order dated 871. Order dated so and so, fast MSLP number so and so, affirming the judgment dated so and so, page 57. And our interim order dated 2nd of April 2025, which is extracted as under. On 22nd of April 25, after hearing the parties for considerable length, we had passed the following order. Report comes. First up. Yeah, it's 22nd of April 25. First up. From the counter affidavit dated 3rd of May 2025.
Supplementary.
My apologies. From the supplementary affidavit dated 3rd of May 2025. Filed by the Secretary of the Paradip Port Authority, bracket may respond number, filed on behalf of respond number 1 by its secretary. We have a considered view that either the respondents have not appreciated the intent, have either not appreciated the import of the order, or they are bent upon not implementing the same in its literal spirit. As such, we are constrained to direct the personal presence of the. You are managing director or chairman?
Chairman, Your Lordship, accounts, Your Lordship, kindly see the accounts, Your Lordship, kindly see the, it's compared to the Vrindavan Das, it has been paid more.
The chairman of the respondent number 1.
Correct.
On the next date of hearing. So, at this stage,
Your Lordship,
counsel for the respondent submits that the affidavit filed is in consonance with the direction issued by the court. And all the benefits which were accorded to Shri Vrindavan Das stands granted to the petitioner. Well, we are not, prima facie, not in agreement with such submission.
Your Lordship, may pointed out from the accounts, Your Lordship.
For, as is evidently clear from the, where is that chart, Mr.
Page 5.
No. That chart is
96. Page 96.
For as is evident from the chart in tabular form, which is part of the writ
petition filed before the
filed by the instant petitioner before the High Court. Chart at page 96. Writ petition filed now. The benefits ought to have been, similar benefits ought to have been accorded to the instant petitioner, as were so accorded to Vrindavan Das. Such benefits are not only monetary, in terms, but also promotional and other benefits. We only hope that for the next set of hearing, the benefits similar to that of Vrindavan Das would be accorded to the petitioner.
Your Lordship, may I submit, Your Lordship?
List on dash. Please advise your client properly.
Your Lordship, kindly see, the scale of rate had been said in the 1993.
Please advise your client properly.
1993. Your Lordship, 1 minute. Your
Don't
Lordship.
defend the indefensible.
Your Lordship, kindly 1 minute, if Your Lordship.
Thank you. What else? Go date. What did we do? The side of the petition.
That seems clear.
Upon the respondent, the order would be complied with.
Your Lordship, the calculation what I have given that Vrindavan Das also still alive, he has been given whatever the Vrindavan Das is getting. And he is getting more than the Vrindavan Das. Vrindavan Das is getting more than the Vrindavan Das.
We'll say if the order is complied with, the respondent need not remain.
Please.
Will not embarrass you. What else?
Your Lordship,
Nothing more can.
Your Lordship, then grant us time to reconcile whatever thing, whatever Your Lordship can get the
at this stage, yes, sir, at this stage, Learned Counsel respondent prays for an adjournment to enabling him to sit with the Learned Counsel for the petitioner for reconciliation of the accounts and the benefits which are required to be accorded to the petitioner. No problem.
so that we can place before Your Lordship for proper.
No. It will be done within 1 week. List on dash.
Your Lordship need 1 week. Your Lordship, this is vacation week. Your Lordship, you might not have time. Your Lordship.
No, he will have all the time. We have all the time. Don't worry.
So I have to call. Your Lordship, 10 days time at least. 10 days time.
1 week. List on that. Put it here next. Hey, Mr. Let's we'll have it some other day.
So Your Lordship, 10 days. Weeks time, 10 days.
Sorry.
I'm sorry, Mulad, I wasn't here, Mulad, I was in court too.
No.
So, Mulad.
This
will take some time, Mulad, at least 45 minutes on my side. My learned friend will also.
40 minutes, what for?
Mulad, there's a number of judgments that I have to take. I'll have to take your lordships through this. We've already given a note. We've already given a notice. Oh, I see. So we'll give a fresh notice what my learned friend is.
Let revised
note
of written submissions be filed by the parties within a week.
Very great.